Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning. Welcome to the second day of our Pittsburgh argument sessions for the fall. Let me just briefly say that after longer than a generation, this will be former Chief Justice and soon-to-be Chief Justice Emeritus Saylor's last oral argument, because it doesn't make sense to sit in December when we're in Philadelphia, because he will not have the opportunity to write cases or to vote on cases because they'll matriculate into January. So we all acknowledge that. We've had programs and acknowledgments, but it bears saying one more time that he has been a wonderful friend, a wonderful colleague, and a wonderful addition to everything Pennsylvania, with his scholarship and his fairness and his genteel and calm manners. So thank you, Justice Taylor. He will, however, be voting on these cases, so you better persuade him. Brian, will you call our first case?
First argument is Carl and Ellen Hughes and John Albrecht versus UGI Storage Company. Representing Hughes and Mr. Albrecht is Mr. Benjamin Johns. Representing UGI is Mr. Stanley Yours.
These consolidated cases present the court with an opportunity to review a taking claim under eminent domain. Specifically, we are asked to consider whether the Commonwealth Court improperly imposed de jure taking elements on a de facto taking claim when it concluded that a court or corporation's ability to exercise its power of eminent domain required that the company seeking to take eminent domain obtain a certificate of public convenience. Mr. Johns, feel free to introduce yourself and proceed.
Mr. Chief Justice, and may it please the court, Ben Johns from the law firm of Chimicles, Schwartz, and Haverford on behalf of the Hughes and Albrecht Appellants. There are three principal reasons why we're asking the court to reverse the Commonwealth. Number one, the decision below is legally erroneous and that it conflated the distinct doctrines of de facto takings and de jure takings. Second, the opinion presents a playbook whereby entities that have the power of eminent domain can game the system at the expense of property owners. And third, as applied in this case, it deprives our clients of their Fifth and 14th Amendment rights. I'd like to set the table, if I may, by briefly telling you about our clients we represent. They own property that's situated in north central Pennsylvania. It's above the Marcellus Shale, and below that is the Utica Shale. Their property also happens to be situated within this area that UGI delineated, a buffer zone, that surrounds the underground gas storage field that UGI operates. The buffer zone protects that gas storage field because it, as UGI says, it's a protective perimeter. It prevents fracking. That's coming from FERC. And so not only is it something that is coming from FERC, but as a practical matter, as we've seen, and this is in the record, there are declarations from landowners, including one of the clients, who say they would love to frack on this land, but they have not had the opportunity to do so because their property happens to be within that buffer zone. And they've actually had prospective drillers contact them and tell them that they can't frack for that very reason. As Judge McCullough said below in one of her dissents, the reality here is UGI has
I ask you, why can't they frack? they can't frack because they're concerned that the Meeker storage field will leak?
Chief Justice Barr, yes, it's UGI has a affirmative duty to protect and ensure the integrity of this underground gas storage field. And as a technical matter, when these fractures occur miles and miles below the earth, nobody knows how far those will expand. And so that's the whole purpose of a protective buffer zone. That's the point. And again,
But that's not your problem. That's their problem, and they won't give you compensation for your land. Is the difficulty that if they frack, both you and they can be liable for damages to the extent the gas or whatever's in the storage field migrates underneath a neighbor's property or the like?
well, the problem is they can't frack and they haven't been provided with just compensation by UGI. And I'll note that that is in direct contrast to both how other gas storage field operators in this same area have behaved. They've paid compensation to property owners. And if you,
Again, though, you owe no duty to them whatsoever. Why can't you frack?
because FERC says we can't frack, Your Honor, that's at page 324 of the record. We go through and we pull out these opinions. It's called Sabinsville, and it is very clear that fracking is prohibited in a buffer zone. Again, that is the purpose of the buffer zone.
And FERC designates the bumper zone?
No, UGI designates the buffer zone. The buffer zones come in all shapes and sizes, Your Honor. Some of them are 2,000 feet, some of them are 4,000 feet. This happens to be 3,000 feet. Those coordinates didn't come from FERC, those came from UGI. So it was UGI that delineated this proposed buffer zone, and again, that's the problem here, is our client's property's in that, and they haven't been compensated, and they've lost the ability to put that land to its highest and best use.
Does your client live on the top, on the surface of this land?
Yes, they own, yes. So, as Judge McCullough said in one of her dissents, this conduct has isolated these landowners on an island because the world, again, is on notice of what I just said, that fracking is prohibited, and yet UGI's provided no compensation. This is all directly contrary to a representation that UGI made to FERC in 2010 at the time that it was applying for the buffer zone. This is at page 116 of the record, and what UGI said to FERC was, we don't own this property in certain properties in the buffer zone, but we will pursue what's called a landowner notification process, and we will seek to acquire the property rights in that buffer zone. Now, this was 11 years ago, and that has never occurred. And again, not to repeat myself, but that's contrary to how other gas storage field operators have behaved. And if you look at footnote 1 on page 1 of our reply brief, it's also contrary to another property that's in this exact same Meeker buffer zone. That's the Faveyard case I'm referring to that went to a board of view for the same claims we're here talking about, and the board of view there awarded in excess of $500,000. Now, of course, we're not just here today and taking this appeal because UGI didn't honor its representation that it made to FERC. We're here, of course, because the Commonwealth Court made a legal error. The majority opinion below recognized that UGI has the power of eminent domain. It acknowledged that it's 100% up to UGI whether and when to take any affirmative steps beyond what it's already done. And it also recognized the representation that UGI made to FERC that I just alluded to in the application process. The majority opinion nevertheless dismissed the case because it found UGI hadn't actually exercised its power of eminent domain with respect to these properties. We submit, Your Honors, that turns the de facto takings clause on its head. As President Judge Leavitt said in her dissent, that analysis does not account for the difference between these two doctrines. A de jure taking, of course, is when there is a formal condemnation initiated by the condemnor in, quote, compliance with all of the statutory requirements. De facto taking, on the other hand, by definition, occurs outside of the legal process where there's no declaration of taking that's filed and eminent domain has not been formally exercised. And so as Judge McCullough said, this is a 5-2 decision, there's two dissents. Judge McCullough in her dissent says that by putting this additional requirement that UGI exercise its power of eminent domain essentially requires us to prove a de jure takings claim in order to state a de facto takings claim. We submit
Leaves you helpless, does it not?
that.
Because they have, under your theory of the case, I'll have to hear the other side. They have the discretion to get or not get the certificate of public convenience. If they get it, it's a de jure taking. If they don't get it, your theory of the case is they got what they want. They have their buffer zone, and they didn't have to pay for it.
That's exactly right, Chief Justice Barr. It's the fox guarding the hen house. And again, as we know, this wasn't last year. This was 11 years ago that this happened. So we know that they're not going to do that. And we know this because UGI is a for-profit company. It's a rational economic actor. It knows it doesn't have to provide this notice to these landowners because it's getting away. It's getting the full benefit of the buffer zone without providing notice and without providing compensation. The correct standard that we're asking this court to, I won't even say adopt, because it's essentially reiterating what goes back to at least as far as this court's opinion in 1974 in Conroy Prue, was reiterated by Justice Newman's opinion in 2006 in a case called WBF that involved the Lehigh County Airport expansion. And both of those cases are still good law because Justice Donahue cited that in this court's opinion in PBS Coles that was issued this year. The rule from these cases is when you have an entity like UGI that has the power of eminent domain, that has engaged in pre-formal condemnation activity or pre-de jure activity, and that conduct has the effect of substantially depriving landowners or property owners with having the ability to put their property to the highest and best use, that's a de facto taking. And by the way, that is consistent with a line of cases from the Commonwealth Court, a case called Assaline, case called Mountain View. We cite all these cases in my brief, and I won't read them all out loud because I'd just be repeating myself. They all say the exact same thing that what I said. And one other point I'd like to make.
The other point is, this was on preliminary objections, so you didn't even get a chance to go into court and try to prove a taking. Isn't that correct?
Your Honor, that's right. And I'm glad you asked that question, Justice Saylor.
That's what we're talking about. Was there sufficient, a basis here to put you out of court on preliminary objections?
That's right, Justice Saylor. And we think as a legal matter, we've stated a de facto takings claim for the reasons I just articulated. And some of these things, like the FERC opinion that I was discussing with Chief Justice Barr, that's essentially
everything you're talking about are things you put into evidence.
That's right.
You're allowed to go forward to try to prove that there was a taking.
Correct. And the reason I'm glad you asked that question, Justice Saylor, is because I think it's important for the court to be aware of the procedural posture of this case when it came up. At the time, Judge Anderson in the trial court sustained the preliminary objections. We had a pending motion for discovery sanctions, a motion to compel. We had only been provided with like 150 pages of just maps and things that are irrelevant. And as Justice Saylor alluded to in that question, of course, in these types of takings cases, the facts matter. And we didn't have an opportunity to get depositions. We didn't get into the UGI file cabinet that dealt with the Meeker storage field application. We never got a straight answer as to why UGI represented to FERC in 2010 that it was going to provide notice, it was going to compensate these landowners, and it didn't. And I'd like to add one more thing, which is what UGI is doing here is trying to really make this case very simple. They're saying, we're a FERC-regulated entity. We don't have a certificate of public convenience issued by FERC. Case closed. We don't have the power, or we're not going to be able to exercise the ability of eminent domain. The problem with that analysis is in every single case I've read including PBS Coles, including the majority opinion below, courts have said that there's no per se rule for a de facto taking. There's no bright line test. The facts matter. And so I would submit, and again, as PBS Coles says, when you do, the way you analyze these cases is you look at the reality of the situation.
Well, if somebody takes your property, you have a right to just compensation. Doesn't make any difference whether they had the right to condemn it or didn't have a right. Isn't that your point?
Yes, Your Honor. Yes, Your Honor.
But in the court, you prove that there was a taking. They call it a de facto taking. If they landlock your property, they've in effect taken your property.
Correct, Your Honor. And again, the focus by UGI as well as by the majority opinion, by just putting the blinders on and looking at the FERC application and whether there was a certificate of public convenience issued, that's not relevant to a de facto takings claim. And that's Judge Leavitt, the president judge of the Commonwealth Court, she wrote a separate dissent. And she said, irrelevant. That's her words. Irrelevant.
Is there any evidence in this case, and we'll ask them, but you don't get rebuttal, that UGI cannot get a certificate of public convenience as opposed to not wanting to because it would cost them money?
No evidence in the case, but I think the answer to that question, Chief Justice Barr, is pretty self-evident. I can give you a one-word answer. It's money. They don't want to do that, and they don't have to do that because, again, for the last nearly a dozen years, they've gotten what they wanted.
But to your knowledge, understanding this case, there's no legal impediment to them getting a certificate of public convenience. Is that accurate?
That is accurate. I mean, this is something that the Commonwealth Court talked about the ease by which they could get it. Certainly, they've already got some property rights that they've been able to obtain within the buffer zone. But again, our position is that's not relevant. It's relevant to a de jure taking, but it's not relevant to a de facto taking. And therein lies the problem again with what the Commonwealth Court did by blending these two distinct doctrines together. And we submit that if that's not clarified, it's going to eviscerate the doctrine of de facto takings.
And I take it that neither the Federal Energy Regulatory Commission or any state entity will get involved because, based upon your history, there's been some misrepresentation made to them.
That's exactly right, Chief Justice Barr. Exactly right. And I would add to that with respect to the relevant state agency, which is the Public Utility Commission, UGI has taken the position throughout this case, as I was alluding to earlier, we are a strictly federally regulated entity. We have nothing to do with the Pennsylvania state entities. But to answer your question, no, neither is going to do that. And that's why we're here. We have a viable de facto takings claim under well-established Pennsylvania law. The other thing I'd like to add to that, I just rattled off a number of Supreme Court cases and Commonwealth Court cases from this state. Our brief also talks about a case that I think is pretty persuasive. It's called Corsello versus Verizon. Of course, I acknowledge, as we do in our brief, that it's not binding on this court because it's a decision from the New York Court of Appeals, but it's very helpful, I think, in analyzing these issues because it talks about the unfairness to property owners to, again, give 100% of the discretion to the condemnor to essentially make the claim ripe to sue for a de facto takings. Verizon, in that case, it was an apartment building in Brooklyn that Verizon had affixed a cable box to, and Verizon essentially said, you can't sue us because we haven't perfected our de jure taking of this property. And the New York Court of Appeals said, that doesn't make any sense at all. That's unfair to property owners. And we think that's very analogous to what we have here.
Counsel, perhaps you could clarify something for me, and I'll ask Mr. Yours this as well. It seems to me that under their construction of the requirements for a de jure taking and then the law for a de facto taking, there would be no need ever to pursue a de jure taking. There would be no need to ever get a certificate of public convenience because they could accomplish the same thing with a de facto taking. Am I missing something, or is that the sum of it there?
I think that's more or less correct, but of course the problem...
Tell me where it's less correct, because I need to know that.
I think the problem with that is, again, they're not providing these landowners with the just compensation that they're entitled to under the Constitution as well as the eminent domain code. So whether it's a de facto, it's a de facto taking, and they're not able to put this land to its highest and best use.
No, I understand that, but why then would there be any purpose of getting the public convenience certificate and pursuing a de jure taking? Why would that even happen?
I understand your question now, Justice Todd. The point is that there's no reason for UGI to ever do that. And again, that's why they haven't done that in 11 years.
Okay, so rather than being more or less correct, I was more correct.
Yes, Your Honor. As Chief Justice Barr had mentioned, I do not have the right of rebuttal under the court's rules. So I'd like to conclude by, there are a couple of points that I anticipate you're going to hear from my friend Mr. Yours, and I'd like to address those briefly if I may. One of those is, nothing that UGI is doing here is preventing these landowners from fracking in the buffer zone. And again, the problem with that is it runs straight into the FERC guidance that I mentioned before that you can find at page 324 of the record. The other point that I quickly want to mention is UGI is going to say, well, we don't have a certificate of public convenience either from the PUC or from FERC. Once again, that is irrelevant. That is a de jure taking concept. This is a de facto takings case. And then the last point that I'd like to address is there's some discussion in the briefs about takings and, about trespass. And they suggest, as does the majority opinion of the Commonwealth Court, that, oh, no problem here, you can sue and trespass. The problem with that, if you look at the cases that they cite, is it doesn't fit here. A trespass is typically something that's done negligently with good intentions, but there's a problem. A lot of these cases arise in the context of wastewater storage systems, and there's an accident, and courts say that the proper claim there is for trespass. On the other hand, where you have an intentional action, deliberate scheme set up by the condemnor, cases are pretty clear that that's a de facto taking.
And the remedies are different too. Trespass remedies are less robust than remedies under the code, right?
Yes, that's right. That's right.
And also, I mean, in preparing for the case, I don't see where there's any trespass whatsoever. You're not going onto their land. They're not going onto your land.
Yes, that's right.
We've had a case in the past where somebody was fracking, went down, and the pipe went horizontal onto a neighbor's property. Well, that's a trespass. Here, nothing like that's occurring.
That's right. When I think of trespass, I think of physical touching, and as you said, Chief Justice Barr, we don't have that here. So that's right. So unless the court has any questions for me, I would again like to just reiterate and conclude by saying that the court below, if it is affirmed, is going to eviscerate the claim or doctrine of de facto takings, and I would also submit it would be just bad policy for this court to endorse. And so for that reason, we respectfully request that the court reverse the Commonwealth Court.
Thank you.
Thanks.
Counsel? Given the gentleness with which your opposing counsel's been treated, you probably have a uphill battle here. Anxious to hear what you want to say.
I plan on going downhill all the way.
An uphill battle with no buffer,
No buffers.
Good morning, Justices. Mr. Chief Justice, Stan Yours for Aplt UGI Storage Company. Let me start by talking about the procedural aspects of this case, and this ties into, Justice Saylor, your comment a few minutes ago about preliminary objections. Preliminary objections were filed in this case, but recall that preliminary objections in an eminent domain case are different than what we're used to preliminary objections in a normal civil case, where the court is simply deciding it on the law and no evidence. 504D of the eminent domain code states that the court, in the first instance, has to decide whether there is a de facto taking. And there, at that time, even with preliminary objections, you can introduce evidence. In fact, that's what the Commonwealth Court did. The last time we were in the Commonwealth Court, no, I'm sorry, the first time we were in the Commonwealth Court, the court said, you go back and have an evidentiary hearing. And when Mr. Johns was reciting a number of alleged facts to this court, it's important to note that there was no evidentiary hearing in the court below, in the trial court. The Commonwealth Court sent us back for one, but at 573 and 574, 573 and 574 of the record, the court directing this to Mr. Johns. So you don't want an evidentiary hearing at this point. Attorney Johns, exactly. There is no evidence in the record, as Mr. Johns was speaking of, with regard, for instance, to what other gas companies are doing, what UGI might have done in other cases, the Faviard case that he mentions, to which he attached in his rebuttal. That wasn't in the record. Nothing is in the record in this case. He spoke about some landowners complaining. That's not in the record in this case. We were in the trial court most recently on a narrow issue, that is whether UGI had the power to condemn. And the trial court said, you do not have the power because FERC specifically says, the Natural Gas Act specifically says, UGI or any natural gas company, you have to come to us first before you want to operate a pipeline, before you want to operate a storage field. We have to give you a certificate. Now, if you get the certificate, then Section 1717 FH of the Natural Gas Act says that you then have the power of eminent domain. If you cannot reach an agreement.
A certificate of,
I'm sorry.
a certificate of what? Is this the certificate of public
This is
convenience?
the certificate of public convenience and necessity. That's
But
correct.
that's for purposes of eminent domain, correct?
No, Your Honor.
Is that for purposes of running a storage facility?
Absolutely.
Okay.
You cannot, that's why you go and get the certificate of convenience and necessity. The Natural Gas Act says you can't operate these unless you get it from us.
But is it true also, Mr. Yours, that you cannot effectuate a de jure taking unless you have the certificate of public convenience?
Oh, yes, as I say, 717 says that only when you get the certificate of public convenience do you have the power of eminent domain, and then you can effectuate a de jure taking. But
So therefore, given that you have the certificate, you can use eminent domain on your opposing counsel's, the client's part.
no, we cannot, Your Honor, because
But you don't have the certificate for all of the buffer zones.
correct. In 2000,
Well, wait a second, because let's straighten this out before we move on. Do you need a certificate of public convenience to operate the Meeker storage field? Yes or no?
yes,
Okay.
and we have that.
And do you need something different for purposes of eminent domain?
Well, it depends which parcels you were talking about, Mr. Chief Justice.
All right, so you do need, so the answer then to my question is you do need something different to engage in eminent domain.
Well, on the appellant's properties, yes. We do not have a certificate of public convenience and necessity on appellant's properties.
Yeah, but you're not here, are you arguing something different than, I thought the only fight we're having, so to speak, at this point is on the third factor, that the power issue is not the issue here today, isn't that right?
I do not think so, Justice Wecht. The power issue is inextricably intertwined with the exercise issue. That's why we mentioned the Penn East versus New Jersey case decided earlier this year by the U.S. Supreme Court. Justice Roberts, writing for the court, said, quote, eminent domain power is inextricably intertwined with the ability to condemn, we have even at times equated the eminent domain power with the power to bring condemnation proceedings. An eminent domain power that is incapable of being exercised amounts to no eminent domain power at all.
Well, if your reading is correct, if, I don't mean your reading of that opinion, I mean your reading in this case is correct, when would there ever be a de facto taking? I mean, aren't you just writing it out of the law?
No, certainly not. If the difference between a de jure taking and de facto taking is fairly simple. In my simplistic mind, a de jure taking is, okay, you have the power to condemn, and then you file a declaration of taking or a petition under section 1511 of the BCL, and you go and have a hearing before the Board of Review to determine just compensation. De facto taking, you have an entity with the power to condemn who does not follow that, who simply goes onto a property or takes a property interest. And in both cases, Your Honor, the one common thread is that you have to have the power to condemn. So it's not writing the de facto taking out of the law at all.
So you think that puts them out of court? I mean, in other words, you think that's a distinction that holds in this case, putting them out of court on the de facto taking claim?
Absolutely. I'm
sorry, go ahead, sorry.
Unless you have that power to condemn, you can't have a de facto taking. Now, the Commonwealth Court, and as the court knows, UGI argued in the Commonwealth Court that we simply don't have the power at all because we don't have the certificate. The Commonwealth Court said, well, you really do have the power, but you can't exercise that power without the certificate. And so the third factor is knocked out.
Construction is correct. This is where I don't understand.
Sure.
If your construction is correct, then why would you ever need to pursue a de jure taking or to effectuate a de jure taking? Because if you can avoid filing the certificate of public convenience or obtaining a certificate of public convenience for part of the land in question, and yet you can effectuate a de facto taking, then why would you ever need a de jure taking?
Well, for these particular properties, Your Honor, I apologize. I mean, we, in another life, I represent gas companies, and we effectuate jure takings all the time. We file under 1511 of the BCL and go into court.
Sure, and that would be the norm. But if you can do what you're trying to do in this case with a de facto taking, why would you actually ever need to do what you normally do, which is get the certificate of public convenience and make sure you've effectuated a de jure taking?
Well, I'm not sure we're trying to do anything, Your Honor. We simply don't have the certificate right now because the FERC in 2010 decided that we had UGI had not effectuated landowner notice.
Right, but you're claiming the right to a de facto taking, or you're claiming that you cannot do a de facto taking because you don't have the public convenience certificate?
Correct, because we do not have that. Now again, Commonwealth Court said, you do have the power, but you can't exercise it. Either way, from my point of view, UGI wins.
That's what I
Well,
mean by
it
the
depends on whether there is in fact a de facto taking or anticipatorily a de facto taking.
Well, no, I think, Your Honor, at least at this stage, all we're talking about is the first factor, whether UGI has the power, because that's what we argued in the trial court. Now, the Commonwealth Court said, look, we can affirm the trial court on any basis, and that's when they went off on the third factor in a de facto taking, which is that you have to have you have to exercise. The damage has to be the immediate result of the exercise of the power. And the Commonwealth Court said, well, you can't exercise the power because you don't have a certificate.
Counsel, I'm really, I'm just confused about the argument, I think.
Sure.
Your client could have included these properties within the original application for a certificate of public convenience. if they had just given the appropriate notice to the property owners. For whatever reason, they didn't. Some property owners were given notice who were in the buffer zone, and they were included within the certificate of public convenience. So I just don't understand where this notion comes from that you are not able to exercise the power in this case. I mean, the FERC gave your client the opportunity to effectuate the appropriate notice and to gain a.
In 2009, when UGI applied for the Meeker storage field, UGI argued in that application that it did not have to give landowner notice as generally required by FERC because it was simply a jurisdictional transfer from CPG, Central Penn Gas. And that is why landowner notice was not given. Now, FERC later on in 2010, when it came out with its order, disagreed with that and said, okay, you didn't give this landowner notice, so we're not going to certificate you for these properties. And that lack of certification means that UGI does not have the power. Again, in Penn Gas, in Penn East, the U.S. Supreme Court consistently says it is the certificate holder that has the power. If you're not a certificate holder, you don't have the power, and hence you cannot effect the
Can I
condemnation.
jump in?
Counsel,
Why don't,
you can, but you do have the power.
Yeah.
You're just choosing not to exercise
No,
it.
no. With respect, Your Honor, we do not have the power. Now,
You have the power to seek a certificate of convenience for this land. FERC said that.
Right,
Come
no,
back and
yeah.
give notice.
Right. Now, that is a different question, though. If you're asking, is UGI capable of going back to FERC and potentially seeking certification for these properties, I have to say, yes. I mean, it is possible to do that. Whether FERC gives them the certificate on these properties, that's not clear. There's nothing in the record to indicate that that is a sure thing, because FERC, in these, the examination that FERC makes of an application, FERC says is a searching examination that is dependent on factors. For instance, I'll just give you an example. In 2000, CNG applied to FERC for a 2,000-foot buffer zone in the Tioga field, very close to the Meeker field. FERC rejected that and said, no, we're only going to give you 1,000. It is unclear if UGI applied for certification here, whether FERC might look at it and say, you know, things have changed since 2010 when we first gave you the certification. Fracking has gotten better. We're more intelligent on our use of fracking. We're not going to give you certification.
But counsel, that's an entirely different issue. That's an entirely different issue. I mean, what you were talking about initially was the inability to seek certification. I mean, that's just not that. You're talking about maybe what Judge Levitt was referring to is it may be a difficult case, but they have an opportunity to prove it. I mean, the issue that we have before us is whether or not this is a de facto taking, and I think the first question, which I think we all agree on, is you have to have the ability to exercise eminent domain. That's what we're talking about. And I just don't see how you can construe the statute or actually the background facts of this case and come to the conclusion that you don't have the ability to exercise eminent domain. You're just choosing not to. That's why we have de facto taking cases.
Well, Your Honor, in a de facto taking case, again, it's not as if the case law says, as I read it, that an entity doesn't have to be clothed with eminent domain power. All the entity has to do is possibly have the ability to obtain eminent domain power. That's not what the cases say.
But even the
Cases say-
Commonwealth Court majority said you have the power. It seems you're trying to improve on the favorable decision you got below by getting the benefit of the original trial court framing. I guess suppose perhaps you're taking that approach to avoid 502C. I mean, it seems under your approach to the case, 502C just is written out of the law. I mean, or de facto takings just don't exist. And it seems to me a very creative approach to what's really happening here, because they're deprived of a remedy on a taking. I mean, I guess that certainly is going to run into a headwind from SCOTUS, I would think.
Well, Justice Wecht, I think you give me too much credit for being creative. All I'm trying to do is look at what the cases say, and with regard to what other remedies there might be, the ingenuity of the plaintiff's bar is legendary. There may well be remedies, but it's not, I don't think it's my job or this court's job, frankly.
Ingenuity aside, counsel, we're talking about what the Commonwealth Court said in this case, which is that you have the power to condemn.
Right.
And do you agree with that or not? I mean, are you challenging that aspect of the Commonwealth Court's opinion?
Well, no, since the result in the Commonwealth Court was correct in terms of result from our point of view, we're not challenging it. I think, to be blunt, if the Commonwealth Court had the benefit of the U.S. Supreme Court's Penn East case where it made that decision, they might have decided differently. But I'm happy to rest on the Commonwealth Court's decision, because when you look at it, it said we can't exercise that power without a certificate. And I don't see how we can argue, how anyone can argue with that. It's in the law that we can't exercise the power to condemn without a certificate.
Isn't this case analogous to me suing Pennsylvania because they won't let me drive? And they say, well, you didn't take your test. You didn't go get your license. And I said, I don't have to do that. You're saying we don't have the power to eminent domain because we don't have a certificate of public convenience, and we have no intention of applying for one. So as he said, you have the fox guarding the henhouse.
Well, first, I have no idea what my client will or will not do. Again, there's absolutely no record evidence here with regard to whether they...
I can walk down and take the driver's license. Why can't you go down and get the certificate of public convenience?
Well, you probably would pass your driver's license test, Your Honor, but maybe not. And that's what I was saying earlier. Even if UGI applied to FERC, there are no guarantees that they would get that certificate.
But the whole point is they don't need that element. And were they to need it, then you would have eviscerated or just eliminated de facto takings generally or completely.
No, because, for instance, all of the de facto takings cited by Mr. Johns in his briefs, in all of them, and most of these are PennDOT takings, PennDOT has the power to condemn and the power to exercise that condemnation. They've got it right there. And that doesn't mean de facto takings are eviscerated. And that's what the argument here is. Even if you go by the Commonwealth Court, say, okay, you have the power, look at the third factor. The third factor, the property owner must demonstrate that the deprivation is the immediate, necessary, and unavoidable consequence of the exercise of the power to condemn. Without the certificate, we can't exercise it. And so you do not have the de facto taking.
Right, and that would mean they had to have a de jure. They had to, they would have had to have the elements of a de jure. So you've conflated, just conflated de facto into de jure.
No, with respect, Your Honor, as I mentioned before, the common factor in both de jure and de facto is the ability to condemn. I mean, the distinction is, I think, the distinction is that in the de jure, you actually go and file the condemnation and declaration taking. In the de facto, you still have to have the power to condemn. I mean, both this court and the Commonwealth Court say that in all the cases. So if you want to say that's conflating, well, it's not. It is only that one factor is common to both de jure and de facto.
Counsel, if I just may.
Sure, please.
How does Natural Gas Act 717F, I think H, come into play in which, with the It seems that you're trying to sidestep, trying to negotiate and give some value to the property owners by your argument. Tell me how I'm wrong. Under your argument, by de facto, you don't have to deal with the owners, you can just take it. But by doing de jure pursuant to 717FH, you have to negotiate and/or agree with the property owners as to just compensation before you can even move for eminent domain.
It is correct, Your Honor, that under 717 FH, if we obtain the certificate prior to condemning the property or entering into a de jure eminent domain, we have to make at least some effort. And some courts say a good faith effort, some say just an effort.
So in de facto, there has to be no effort whatsoever.
Right, a de facto taking, once we have obtained a certificate, if there is a de facto taking, we don't have to. Remember though, Your Honor, the law does not favor de facto takings. I mean, remember, in terms of a de facto taking, one of the elements of damage is attorney's fees. I mean, we don't get that, landowner, if a de facto taking is found, then the landowner gets their attorney's fees for that. So, I mean, it's, one of the questions early was, why would you ever have a de jure taking? Well, among other things, if you have a de facto taking and it is found to be de facto taking, we're on the hook for attorney's fees, which in many cases can be considerable.
But much less negotiating property rights with the landowner.
Well, having done this a lot, I can tell you that many boards of view are very partial to property owners as opposed to gas companies. And so I'm not sure I would entirely agree with that.
Well, that would be a good reason why, again, I'm not asserting anything underhanded, but that would be a very good business reason why your client would want to make sure that they were consigned to a trespass theory, if they could find one, and not be able to avail themselves of a de facto taking, because they've got the attorney fee avenue.
But with the trespass theory, Your Honor, they face the prospect of punitive damages if the trespass is found to be intentional. So I'm not sure I would agree with you that that is a good business reason. Frankly, it may be a better business reason to avoid the idea of a board of view, I'm sorry, not in trespass, of a jury looking at a gas company intentionally trespassing on someone's property.
And I think we're done here, but just for one last question, where's the trespass? How are you going on their property?
Well, I'm not sure there is, Your Honor. I mean, the Commonwealth Court, the Commonwealth Court said, hey, this might be an option. Are there other options? Perhaps nuisance, perhaps others. But again, it's not my job, or I think this court's job, to find other options, just to determine now whether there is enough to go on and have a real evidentiary hearing. I don't think there is. Leave it to you.
Thank you very much. Well argued.
Thank you, Your Honor.
In this matter, the state police conducted a warrantless search of a vehicle, finding probable cause for the search solely in the odor of burnt marijuana emanating from the vehicle. In response to a motion to suppress, the trial court found that the police officers lacked probable cause to conduct the warrantless search because the odor of marijuana was no longer presumptively illegal because of the enactment of the Medical Marijuana Act. The Superior Court vacated the order, finding that the odor of marijuana continues to be a relevant contributing factor for a determination of probable cause on a totality of the circumstance case. And we granted allowance of appeal to determine what weight, if any, the odor of marijuana should be given to the probable cause analysis in light of the enactment of the Medical Marijuana Act. We also granted L.A.K to determine to what extent this court's decision in Commonwealth v. Hicks applies to the possession of the medical marijuana. And Hicks was a case, which I trust you know, where a partially concealed firearm could not serve as the sole basis for reasonable suspicion to stop and frisk the carrier of the firearm because of the lawfulness of carrying firearms in Pennsylvania. So, again, a multi-question issue to ponder. If I correct anything that's wrong, and if not, we understand the case, so you can proceed directly to argument.
Thank you, Mr. Chief Justice. May it please the court. My name is Joshua Kerrily from Allentown, and I represent the appellant Timothy Barr in this matter. What the court decides in this case will immediately impact hundreds of thousands of Pennsylvanians across this Commonwealth. And within the next decade, I believe it will impact over 1 million Pennsylvanians. For years, the odor of marijuana has been the most used and, I would submit, most abused basis for conducting warrantless searches across this Commonwealth. And it was because in Stoner, the twin pillars of the plain smell doctrine, the immediately detectable odor of marijuana and distinguishable odor of marijuana, as well as the universal illegality of marijuana that allowed the police to conduct these warrantless searches. As the Superior Court agreed with our position below, the MMA Act, by legalizing marijuana, and not only legalizing marijuana, but also by immunizing those that are in compliance with the act from arrest and prosecution, no longer obviously made marijuana per se illegal. And also the facts of record in this case, and you're aware that we called Dr. Gordon to establish that there is no distinguishable difference, none whatsoever, in appearance or aroma, whether burnt or raw, between street marijuana, I'll say illegal marijuana, street marijuana, and medical marijuana. So with that as the basis, we submit that there can now, after the Medical Marijuana Act, we cannot allow a commonly licensed activity that hundreds of thousands of Pennsylvanians engage in every day, and it's increasing by the tens of thousands every month, to serve as a basis for a constitutional infringement. So where we take issue is twofold with the Superior Court's decision below. And I'm thankful that they overturned what I would characterize as a per se search based upon the odor of marijuana. But we'd like this court to go one step further, because I believe that if you don't, we're just going to continue to run into the same problems that we have had prior to your decision in Hicks. We would like you to state, because the odor of marijuana can never form the basis for probable cause for a warrantless search, because it can never, under any circumstances, we believe that it should be afforded no weight in the totality of the circumstances analysis for conducting warrantless searches.
Why can't it just be a factor in the totality of circumstances?
Well,
Why can it not be considered one factor to help create the necessary reasonable suspicion?
I appreciate that question, and I think that the difference is that the totality of the circumstances, and we're not taking issue with that standard, the totality of the circumstances takes into account the entire picture, whether it be lawful conduct or unlawful conduct, and we don't take issue with that. What we are suggesting to this court, and what we believe that you should rule upon and take issue with what the Superior Court had said, is that what weight is to be given to the odor of marijuana with these warrantless searches. What weight is that to be given, now knowing that you can't tell whether or not it's from a lawful source or an unlawful source?
The question becomes one, under the per se, a lot of weight was given. Under your rationale, no weight's given. So when you say weight must be given, is it your position we're not to give it any weight, or the officers to give no weight? And if not, what is the weight that you believe
But
is?
my position is that it should be given no weight or very, very little weight, because the odor in the air that, oh, by the way, is very difficult to detect, and police officers are bad at detecting it and often miss the point when they're making those searches. But it's always going to be a suspicion or a hunch. We're even one step past the Hicks concealed firearm issue.
But counsel, you would concede with me that under the drunk driving or driving impaired, any amount of marijuana in your system, any, is sufficient for a conviction, unlike alcohol, which there has to be a legal limit. Or so with that, with us having a statute on our books that say any amount of marijuana in your system is justifiable for a stop on a DUI, how are we not to give the smell of marijuana in a vehicle some weight?
Yeah, I believe that this court will probably at some point have to take up the issue of medical
We got it
marijuana.
right now, so answer.
Okay. So with that question, like you said, any amount of marijuana is sufficient. So that takes away the commonly licensed aspect of medical marijuana and the reason that that person driving could have been ingesting the marijuana. It's not an issue under those circumstances.
But isn't it fair to say even with medical marijuana, you're instructed not to drive while smoking?
Absolutely, and it wouldn't be enough just with the plain smell of marijuana under those circumstances too. And
Okay, I'm just trying to follow your argument because it's somewhat, you're contradicting yourself, at least in my mind. You don't want us to give any weight to the smell of marijuana, but the fact is we know, because it's medical marijuana, but we know even with medical marijuana, you're not allowed to drive a car.
right, under those circumstances you
But
can.
I'm not to give any weight, or the officers not to give any weight to the smell of marijuana in a car because it's legal, despite legal marijuana, you can't be driving.
Correct. So with the DUI analysis, any amount, whether it's lawful or unlawful marijuana, is problematic. So it takes away the potential for complying with the license for medical marijuana. It's of no moment in that
Isn't the
circumstance.
issue here that there were 3 people in the car, so that the hypothetical, I was going to ask you about Justice Dougherty's hypothetical, because you have that issue when there's just the driver. But is it a different paradigm when there are 3 people in the car? How should we handle that circumstance? Is there some sort of different rubric that we should craft for the scenario you have, where there are 3 people, as opposed to the circumstance of a plain smell with the one person? You see what I'm saying?
Absolutely. And as you all know, in this case, my client was the passenger. He wasn't operating a motor vehicle, and that's what we took issue with. And I think when it's readily apparent on the circumstances, and if I can understand your question, when it's immediately apparent that they are not complying with the Medical Marijuana Act, and therefore there is no notion that the smell that is coming from whatever the source, whether it be a warrantless search on the street or whether it be within a automobile or a home, whatever that is, when that's readily apparent, then I think that can be carved out, because it loses the protection of the commonly licensed activity.
And on that commonly licensed thing, sorry, I cut you off.
Sure.
On that commonly licensed thing, how should we treat if the actor produces to the officer an MMA card? not mixed martial arts, but medical marijuana, card. I gather from the Commonwealth's papers that the Commonwealth takes the position that unlike a concealed carry permit, that MMA cannot be immediately verified. Can you weigh in on that?
Yeah, that is correct. It cannot be immediately verified because the Medical Marijuana Act does not permit law enforcement to have a list of people that qualify under the act. That's the statute. But what I can say about that and how you treat that, I think, let's take the second issue here in the Hicks decision, okay? Which the Superior Court said did not wholly apply here. I take issue with that. If you would interchange concealed firearm in your Hicks decision with medical marijuana, the entire analysis would hold concealed carry permits. So in the Hicks case, you said that we are not even going to allow the police to question whether or not that person has a license to carry because people complying with the law, we're not going to lessen their constitutional rights.
Well, but Hicks said without more.
Right.
And you're arguing a dissimilar position to Hicks because you're saying that if there's marijuana smell coming from this car, that can't be considered along with other factors, that there's a gun on the front seat, that the marijuana in it are big bricks or little baggies which are packaged for sale. In the case of Justice Dougherty's hypo, that the guy is the driver and his car is weaving back and forth between lanes, which would indicate something. And so the police officer says candidly that the marijuana played a part. The concealed carry can play the part in a stop and frisk or a search with probable cause if there's other matters involved. All Hicks says is you can't stop and ask for his papers for no other reason than the fact that he's carrying.
Right, and that's what we say also in this, and we were successful at the trial court. And again, my client did have a medical marijuana card, and he did present that to the officer, but that highlights the problem and why we need guidance from this court. He searched anyway. He said, we're still going to utilize the smell and plain smell of marijuana to supersede even your presenting of the medical marijuana card, which, oh, by the way, you didn't need to do, and he still searched in any event. So that highlights the issue of why guidance is needed for how much weight, if any, is going to be given to that smell. And what I'm trying to...
There's two other factors were high crime area, which we see in every case, and police experience, which we see in every case. So your argument is, I guess I'm helping you, that the only element here was the smell of marijuana, only real element.
Right, and if you take the Superior Court and let that decision stand, when they go and they remand it back to the trial court and they say, we're remanding this for you to consider those other factors, this was one of the cases, few in my career, where it actually wasn't even in a high drug area. It was in a corridor that was between high drug areas. So it didn't even, in this case, didn't even fit there. But the other thing was that he spent 2 to 3 minutes not wanting to get out of the car in the middle of the night on the side of the road. So if we let that stand and send it back from the Superior Court to the trial court and say, with the guidance that the possession of medical marijuana is still generally illegal, that's what they said, still generally illegal, then we want you to consider that and weigh those factors and then make a probable cause determination. What I'm saying to this court is that I believe that because of the passage of the Medical Marijuana Act and the odor in and of itself not being able to push the needle very far in any event, it should be given very, very little weight, and that should be the guidance from this court. And you also need to say that in Goss, you've already said, marijuana is legal for people who comply with the act, and we're immunizing them. So we can't say that the Superior Court said, it is generally illegal to possess marijuana. It's not. It's not. It's not.
Well, I think that you're misreading the MMA. I mean, the rule in the MMA is except as provided. It's an exception. The use of medical marijuana is unlawful.
Same exact thing for the possession of a concealed firearm. It's unlawful to possess a concealed firearm unless you have a permit for it. So in any commonly licensed activity, and I think what I'm suggesting is that anything that's widespread, that it's reasonable for people who you come in contact with to presumably have a license for, any activity you need a license for is legal with the license and illegal without it. So I think the same thing holds true for the possession of a concealed firearm. Just like, and this taking it one step further, this is the byproduct of potentially lawfully possessing marijuana. This is the byproduct or the odor that's in the air that could have come from anyone.
But in Pennsylvania, can't you open carry a firearm?
Hicks was a concealed carry.
Yeah, but can't you open carry a firearm legally in Pennsylvania?
Sure.
Is that a little different than your analysis with the medical marijuana?
I don't, you don't need a license for open carrying, so that also wouldn't lend itself to a probable cause analysis. You can't go up to that person and say, hey, I think you're committing a crime because I see you open carrying. And I think that it's also the same with Hicks saying we can't go up and we can't question you or use it as any basis to infringe on your constitutional rights because we know that you're carrying a concealed weapon, because hundreds of thousands of people do that in Pennsylvania. And I think with the Medical Marijuana Act only being in effect 5 years as opposed to the decades for concealed carry permits, people lawfully possessing and using marijuana have now superseded that just in those 5 years. So I think it's...
Can I just follow up with you on that, because
Yes.
you keep saying that, and I'm just going to tell, how long is a medical marijuana license valid for?
If it's not restricted, I think they have to be renewed every year, but I'm not positive on that.
And a license for a weapon is good for 5 years, right?
Correct.
So if you have the same number of people every year applying for a license to carry and a license for medical marijuana, you're going to have far more people who have a license to carry a firearm.
Well, the stats are the people that are licensed in that year.
Well, yeah, except for the fact that in that year, you already have people who had a license that was issued 4 years prior to it.
I don't know exactly how they, I don't know exactly how they,
I don't know if you need to make that point as stringently as you're making it,
Understood.
because I'm not so sure it stands the test of analysis. I mean, there have been some estimates that there are, 2 million Pennsylvanians who have a license to carry. We don't have 2 million people who have medical marijuana licenses. Like I said, I'm just trying to test the point and make my point that I'm not sure you have to go that far with your argument.
I understand.
To suggest that it's a more prevalent activity than carrying is in Pennsylvania.
I understand, and I understand, and I understand, and I appreciate that. I think then maybe we could utilize, like in Batista, where there were 25 licenses for grow operations. That is dramatically different than at least the hundreds of thousands of licenses and ever increasing for medical marijuana.
Counsel, if I may.
Yes.
Going back to your original request that we not consider the smell of marijuana by providing any weight. In the case scenario, the Medical Marijuana Act, I believe it's section 1103, permits law enforcement to contact the Department of Health to determine whether the person carries a valid medical marijuana card. In your scenario, if an officer approaches a vehicle, smells marijuana, he then asks for his license and his medical marijuana card. Is the smell of marijuana sufficient as a factor to be considered in the aggregate for the reasonable suspicion or the probable cause that the guy, and assuming he's the driver?
I believe under Hicks that they wouldn't be permitted to request that license, but under your hypothetical, if they request that medical marijuana license and provide it, I think then that obviously would negate any thoughts or dramatically reduce any thoughts that the marijuana that you smell is illegal marijuana.
And considering under the Medical Marijuana Act, it's required for the individual to carry an identification card.
It is.
So I guess the converse, if an officer were to stop a vehicle and chooses not to validate the license, it goes back to the less weight provided to that factor of marijuana, correct?
Sure, but I also think that, again, under Hicks, we don't make people prove that they are complying with that law by allowing for that search. That would be like saying that then we would allow that person or that police officer to go up in Hicks and say, hey, guess what? We heard that you had the concealed weapon on you. I'm going to come up to you and show me your concealed carry permit, or I check it out, otherwise I'm arresting you.
Because that would be going back to the presumptive illegality we rejected in Hicks.
Right, and that's really what issue I take with the Superior Court's opinion, at least in that part. Because again, we started this by per se, yes.
I'm sorry, Counsel. It just strikes me that's wrong because it's not a element of the police officer's right to search that he asked for the medical marijuana card. It's not an element of the defense that he didn't show him the medical marijuana card. It's just a totality of the circumstance argument, and it's nuanced and it changes with every stop on the road. So if it is, and I think you said this earlier, and I think I agree with it, if the person produces a card, that doesn't mean that there's not a totality of circumstance to search if other things are present. It merely means that the element of the odor of marijuana is perhaps dissipated to some extent. And by the same token, if the person doesn't choose to show him a card, maybe just because he dislikes the police and he doesn't want to cooperate, that doesn't mean that he's allowed to search. It's just all part of the totality.
Right, but in that totality, we're just going to keep circling back on this unless we get guidance from this court about how much weight is to be given to that. And
I'm not
You
sure
will.
that's answered. I'm not sure it's like a custody case. Every case is absolutely unique. All the factors are unique, and that's why we need to have confidence in trial court discretion. Not that we won't review it.
I understand, but the odor,
How would we be disappointed if we write totality of the circumstance?
because then it goes back to the trial court, and then they essentially don't have any guidance about how much to utilize the smell of marijuana after the passage of the Medical Marijuana Act, because it is presumptively legal, and it can never, it's the byproduct of what is lawful. So it's actually one step even removed.
Maybe we can help you because I don't think it's going to be presumptively anything.
Okay.
Well, also, counsel, wouldn't that directly contravene Hicks? Because like carry concealed, medical marijuana is a licensed activity. So you can't have a presumptive circumstance within a totality analysis if that is an activity for which hundreds of thousands of people carry a license. There has to be something more.
100%. It's the general illegality that the Superior Court applies to it, and then saying that Hicks does not apply to it as a commonly licensed activity.
At least with respect to a three-person
Yes.
vehicle, that the police can't presume ingestion as to any one person.
Absolutely. Maybe there can be a carve-out for DUI, and you will address that in the case that's in front of you. But for the circumstances in this case, for the warrantless search of an automobile where my client is present, has the medical marijuana card, and there are no other probable cause factors. I mean, the testimony in the lower court was crystal clear. He said, I searched it because of burnt marijuana, and even searched it in light of my client producing his medical marijuana card and the receipts from the recent purchase from the dispensary. So absolutely, Justice Weck.
Counsel, how does Commonwealth versus Alexander affect this case?
100%. I think if it would go back to the court, I would have to obviously raise that, and I think it would be dispositive of it, respectfully.
And I was going to ask you about Alexander. Would it be correct that if you prevail, then examination of the case in light of Alexander would not be necessary, but that if you did not prevail, at least not prevail outright, then you would want remand to look at Alexander?
Correct.
Which is what the Superior Court did, not mentioning Alexander.
They didn't mention Alexander, but they also
ordered
said,
a remand.
Yes, but they also sent it back with the guidance of it being generally illegal and not giving Hicks the weight that it needs to with the commonly licensed activity in these circumstances for a warrantless search of a person in a car not driving.
And then maybe this is obvious. I just want to make sure that I vote correctly. What you want us to hold, you prevail if we hold that that the smell of marijuana is a factor in totality of the circumstances. But under your peculiar case, where you had high crime area, maybe, police experience, and smell of marijuana coupled with a license to have medical marijuana and proof of a recent purchase, that the search was unconstitutional.
Correct, and if we would take it one step further to say, in light of the MMA and the proliferation of people lawfully ingesting marijuana, that factor should be very minimal in the totality of circumstances analysis.
But you don't reject, and I got it. You don't reject totality of the circumstances. You're saying here you win under totality of the circumstances.
Absolutely not. Yes,
Thank
totality of the circumstances stands. We win under the totality, and I believe under these circumstances and with medical marijuana, that should be considered very, very low, especially when somebody presents a medical marijuana card.
Let us hear from Ms. Gallagher.
Thank you.
Good morning. May it please the court, my name is Heather Gallagher. I represent the Commonwealth in this matter and Lehigh County District Attorney's Office. I am very familiar with Hicks, having argued it and briefed it. So I am well aware of Hicks. And I think the one thing I certainly agree where Hicks applies here is the fact that it said that the totality of the circumstances is what is the analysis under any search seizure question.
That's all. That's the only common denominator?
On Hicks, I would also agree with Your Honor where you...
That licensed activity issue also?
The license activity issue, with regards to a firearm, yes.
No. You said the only thing in common, as I understand it, with Hicks is, yeah, it's totality of the circumstances. We don't need Hicks or this case for that, right? That's Fourth Amendment law. But isn't there also and this isn't why the case is here, is that medical marijuana is now a licensed activity in this state.
I would agree with you that it is a licensed activity in the state, but it is not the same thing as a license to carry a firearm. And the reason being is because we have the Controlled Substance Act, and that the Medical Marijuana Act has to be read in conjunction with the Controlled Substances Act. Now, in Hicks, you rejected the elements versus the defense test for that purpose. However, with the Medical Marijuana Act, we keep coming back to medical marijuana being a commonly licensed activity, and I absolutely dispute that.
Well, then you dispute our decision in Gas, which I think might have been a unanimous decision written by then Chief Justice Saylor, in which we said, quote, use or possession of medical marijuana as set forth in the act is lawful within this Commonwealth.
Absolutely. But one of the things that you cannot do is you cannot drive a vehicle and you cannot smoke medical marijuana. You're asking the police officers when, and again, let's go back to the fact that the stop in this case is not at issue. This is not a case about a stop. This is a case about probable cause in a search. And I will agree with you, in light of Alexander, which came after this case, if this were remanded back, the case would not proceed unless I saw some kind of exigency or something that would apply under Alexander. At the time of this case, however, the police, the entire District Attorneys Association across the state were applying Gary. Now, in Lehigh County, we have a local rule, so any search warrants have to be approved by the District Attorney's Office. If I were to get this phone call in the middle of the night asking me whether or not I would approve a search warrant based on the facts presented in this case, absolutely I would. Now, we keep talking, we mentioned high crime area. I did not, and I just went back and looked in my brief, I did not cite high crime area as a factor because I do not believe it was in this case. Now, the officer testified to the fact that he was familiar with this corridor and he had made arrests of this, but I do not believe he testified to it being a high crime area, nor did I rely on that factor. But there were a lot of other factors. For example,
Yeah, what are the factors in the record that would have caused you on the phone in the middle of the night to tell the police officer, go ahead and make that search?
the first factor would have been the fact that they did smell burnt marijuana. Now, we all have heard how medical marijuana that is vaped, it cannot be smoked, but medical marijuana that is vaped and combusted smells the same as street marijuana if it was smoked. Okay, so street marijuana, everybody has been trained, the officers testified their training with regards to the smell of burnt marijuana.
They can tell the difference, you're saying. We should presume that all officers, patrol officers, can perceive by smell the difference between marijuana ingested lawfully under the MMA and marijuana that just comes from doing bong hits.
Well, I would recommend, Your Honor, under the Fourth Amendment and under your analysis, we should not presume anything. So I don't think that you can presume that at all. But what I can say is based on the experience of the officer, which you must consider in the totality, and in the experience of the officer, they recognize the smell of burnt marijuana. Now, I'm not saying they can distinguish whether it's medical marijuana or whether it's street marijuana. However, it's a factor to consider, and that's not all we had here. When he approached the car and spoke to the driver of the vehicle, Mr. Barr was in the passenger seat. Mr. Barr took over the stop, and that is testified to. When the officer did testify to the fact that he asked the driver to step out of the vehicle, and when he asked the driver to step out of the vehicle, which he is permitted to do under the law, and one of the reasons he wanted to ask her to step out, which he testified to, was because I smelled marijuana in the car, and I was concerned with her driving and whether or not she was under the influence.
Can I ask you at that point, counsel, at that point, what could have been the basis for the officer to make any presumption as to which of the three humans in the car consumed the marijuana, if any?
And again, he can't make that presumption. That's why he has to investigate, which he did. And at that point in time, when he asked the driver to step out of the vehicle, he was informed by the passenger, not the driver, because she did reach to open the car. The passenger said, nobody is getting out of this car. And he became argumentative with not only the officer at the driver's side, but the officer on the other side. He was arguing, and he took control of the stop. At one point, when the officer stepped back to open the door to allow the driver to get out of the vehicle, the door was locked, and the passenger said, Mr. Barr said, and I quote, nobody is getting out of this fucking car. Give me the ticket and let us go on our way.
So your position is that's a factor in a totality analysis that has the police officer think that maybe there's criminal activity afoot?
Absolutely, and in fact, the officer testified to that fact.
Let me back you up for 1 second.
Yes, are there any other factors? You were going to list some factors here.
I just listed a couple, Your Honor.
Yeah, two.
I listed the smell of marijuana. I listed the fact that the passenger took over the stop. I listed the fact that the passenger said that the driver could not get out of the car. And I listed the fact that the passenger said that just give us a ticket and send us on our way. There's also the person that's sitting in the back of the car who seems to be in and out of it. Testimony from both sides of it. One was he might be asleep. One said he opened his eyes sometimes. He seemed lulled. He seemed out of it. He could have been the person smoking the cigarette. And at that point in time, nobody had presented a medical marijuana card. So based on those factors.
Well, and you also had the factor of the officer's experience. But the reason that we took this case is that we wanted to try to explore the parameters of the consequences of the Medical Marijuana Act. So your first factor, and I think this is fair, was the emanation of the smell of the burnt marijuana from the car. Does that factor in your mind get reduced if, and I'm not saying they have to, they produce a medical marijuana license? And does it get reduced further if they produce a receipt for having just purchased medical marijuana? And does it get, and I'm trying to figure out how you write this, does your totality get greater to justify a search if they don't volunteer that card and they don't volunteer that receipt? How does that work?
Well, the best way I can suggest to you is in practice. For example, if I were to get this phone call and they said, hey, we pulled this person over, the car smells like medical marijuana, we have nothing else, the person just, or we smell marijuana, I'm sorry, burnt marijuana, the person just presented me with their medical marijuana card and a receipt. And let's go one step further, because this has happened, where the person shows me the packaging and showed me, what do you want me to do? I would say give them their ticket and send them on their way. But that's not what we had.
Did Mr. Hicks have to jump through all those hoops with his concealed carry?
Do you mean Mr. Hicks?
Yeah.
Did he? No, because I was applying the law at that time, Robinson, which said that he didn't have to.
Okay, but I mean, I'm trying to tease out the difference. You've just gone through a litany of things, of hoops, that Mr. Barr would have to do in order to claim the privilege of doing something that is presumptively legal, not presumptively illegal, and we've said so in gas, right? Because this is a licensed activity, just like carrying concealed is a licensed activity. And are you saying that carrying medical marijuana is a lesser order right in Pennsylvania law than carrying concealed, both of which have a licensing regime?
I don't see the correlation, nor do I see that it's something that's putting some onus on. If they pull a person over and they smell marijuana and they say, hey, we smell marijuana, the person's like, oh, I've got a medical marijuana card. I don't understand how that is some big, huge implication.
Let me put my question this way, and then I'll stop pursuing this. You know the Hicks case, you argued it, right?
Yes.
So Mr. Hicks did not have to present his concealed carry permit in order to not be searched under our ruling. How is this case different? There has to be something more, doesn't there? Because marijuana is now a licensed activity by choice of our General Assembly.
What do you mean that I'm afraid I'm confused. We agree that just that alone, there's never a per se thing that gets you a search, probable cause, reasonable suspicion, or anything. And I'm not suggesting it is.
Okay, so you're saying it's the other things, not the odor of marijuana.
I'm saying it's all of those things. I'm saying it's a totality, just as in Gates, just as in Terry. There are innocent factors that have to be considered. In Westby, the recent opinion, in TW, there's always innocent explanations.
Justice Saylor, there's a question for you.
I'm sorry.
I know you're into this. You raised an interesting question, though. Why wouldn't the officer pick up the phone and call the DA and say, look, here's what we have. We'd like a warrant to search this car, and can you authorize the issuance of a search warrant?
They would now. Prior to this, they were following Gary, and as much as I would have appreciated the phone call at 12:30 at night or 1 o'clock in the morning, which we get regularly, prior to Alexander, they were following Gary, and they didn't always call, and that's the reason why.
Counsel,
Matt.
let me follow up, if I can, on your totality of circumstances analysis. If there was no odor of marijuana, would the officers have had the ability to search the vehicle, given the other factors that you've listed?
Without the odor of marijuana, with the other factors, I don't know if I'd approved it. It'd be a close call.
See, isn't that the problem with this
No.
argument? Because the only factor that the officers relied on, and you're relying on your argument, is the odor of marijuana.
No, that's not accurate, Your Honor.
Well, if you wouldn't be able to conduct the search otherwise, then the deciding factor was the odor of marijuana.
No, Your Honor, that's not true. I'm telling you that there's no percentages, there's no certainties under this analysis. You can't take in isolation one factor and then divide and conquer because one factor has some explanation. You cannot do that under the Fourth Amendment and your own case law.
What was
says that.
What was the other evidence that criminal activity was afoot? You had a belligerent passenger.
I
That's
just
what
gave,
you described. You had a belligerent passenger. You used that for three of your factors, but they all lead to the same conclusion, that you had a belligerent passenger. Is that sufficient to conduct a search?
a belligerent, no, there's no one factor that can get you a search. It has to be a totality.
But let me follow up on that one. Arguably, while I understand my colleague's position, it's the smell of marijuana which is triggering the criminal aspect of the stop. Yes or no? Being belligerent's not a crime, it's just lack of manners. Smoking marijuana in a car is illegal.
Absolutely.
Therefore, it can be one factor to be considered in the aggregate with the others, which will reach the totality of the circumstance that possible criminal activity is afoot, correct?
Yes, Your Honor. And where this is distinguishable from Hicks, since we keep coming back to Hicks and the licensure issue, is because we have the Controlled Substances Act. And Your Honor said in the Hicks decision, we in no way hold that the Fourth Amendment prohibits investigation or prosecution of an individual suspected of a crime for which he may have a valid affirmative defense of. And that's what this is. It's an exemption, it's an exception to the Controlled Substances Act, which in the Controlled Substances Act provides a burden of production on the defendant.
I have another question. Going back to the medical marijuana act, in looking at the totality of circumstance factors, the records seem to be absent as to the officer inquiring as to a medical marijuana card, yes or no?
He did not inquire, the defendant presented it.
In those cases in which they're not presented, what is the protocol of the Lehigh County District Attorney's Office to inquire with the Department of Health whether the cards are valid or the lack of one?
Well, the burden of production is on the defendant. If we've charged him and, for example, in this case, at the preliminary hearing, the defendant for the first time presented the receipts of the purchases of medical marijuana. Could we contact the Department of Health? Absolutely. I can tell you in most cases, again, when I get that phone call that they've stopped somebody and the person has presented them with a medical marijuana card and they smell either raw or they smell the odor of marijuana any shape or form, or with now the CBD or any of those items, plenty of times we've had the person show it to them, this is what I have, and they give their warning, their ticket, and send them on their way. So if the person at a later date were to present a valid medical marijuana card for, say they were charged with possession with the intent to deliver or possession of marijuana, and at a later date presented the medical marijuana card, and that was the charge, then I don't know how we would.
But that would make no difference whatsoever to the decision that the police officer made on the scene.
No.
May I ask you just one last question? And this is apropos of what Justice Doherty was asking the opposing counsel. If the only person in this car is the driver, there's no passenger, there's no back seat, then is the odor of marijuana in and of itself sufficient to justify the search on the basis that the Controlled Substance Act, which you alluded to, prohibits? I don't know if it's a Controlled Substance Act. Something in Pennsylvania law says you can't smoke and drive.
That would be under Section 3802 with the Motor Vehicle Act. And if it's just the driver you're saying and they smell, I would treat under those circumstances the same way as you treat the smell of alcohol. If you smell alcohol in the car and you can't discern necessarily who it's coming from, but if you just have the driver, well, that certainly makes it easy. But if you have multiple passengers, I mean, a bunch of college kids coming from a party and the entire car reeks of alcohol, but you didn't stop them for the smell of alcohol, Your Honor, you stopped them for a driving violation.
That you could smell alcohol and he would pass a breathalyzer. But if I understand it, if you smell marijuana, he can't pass anything that would excuse his driving with the marijuana.
Well, if you smell alcohol, even if he passes the breathalyzer, that's not always admissible depending on all the certifications and so forth. So even if you suspect that somebody's not sober or not able, is impaired in some way, they're going to be taken for a blood draw and so forth. They wouldn't base it just on the breathalyzer, depending on the certifications of the breathalyzer and so forth. So if they had the person step out of the car and go through the sobriety test, you know, if they thought that they were impaired one way or the other, that's going to be the decision whether or not to take them. Yeah.
Do you believe, counsel, following up on that, do you believe that we need, in this case, to assess the interaction between the MMA and the controlled, then the vehicle code, 3802? Do you believe we need to do that to decide the case?
To decide the case, no.
And how would you assess the impact, if any, of the provision of the MMA that says it expressly takes precedence over the Controlled Substance Act where the two conflict?
If the person, just as I said, if the person has been charged or the person has medical marijuana and they show their medical marijuana charge, that would take precedence over the law regarding the criminal substance. So they would not be charged with possession with the intent to deliver or possession of marijuana.
Okay, again, that's just to follow up on what the chief said a minute ago. That's cold comfort as to the stop in the search, right?
I'm sorry, I didn't hear.
I mean, that doesn't.
That doesn't prevent the search or and again, we're not talking about the stop because, quite frankly, I don't want to go there on the stop because it's not an issue in the case. Yes, exactly. But with regards to the search, it's always relevant, just like every other factor. Yep.
Ms. Gallagher, I think we have it. We appreciate your expertise in the area. Thank you.
Thank you very much.
We will call you at 1:30 in the In this case, the appellant charter school seeks reversal of the Commonwealth Court's decision affirming the School District of Philadelphia's decision not to renew its charter agreement. Charter school argues that the school district's non-renewal decision was untimely as it was rendered after the charter term expired. According to the charter school law, section 1729A, it requires the school district to render a final decision to not renew a charter school charter at the end of the term of the charter, but not as here after the expiration of the end of the charter in accordance with the appellant's position. And we granted review to examine that statutory construction issue. So go right ahead. Right ahead, Counsel.
Thank you. Thank you, Mr. Chief Justice. May it please the court, my name is David Anacarico, and we represent the appellant in this case, Eastern University Academy Charter School, which I'll refer to as Eastern. Your Honors, on August 8th, 2017, this honorable court issued its opinion in Discovery Charter School versus the School District of Philadelphia. The fundamental fact before this court is that Eastern's charter expired on June 30th, 2017, yet the School District of Philadelphia failed to make its choice to non-renew Eastern's charter until April 18th, 2018, 10 months after the school district engaged the non-renewal process. The school district failed to make its choice to non-renew Eastern's charter during the term or at the end of the term of that charter. The fundamental issue before this court involves the interpretation of 24 Pennsylvania Statute 17-1729, which unambiguously states that during the term of the charter or at the end of the term of the charter, the local school board of directors may choose to revoke or non-renew a charter based upon 6 enumerated conditions. The fundamental precedent that controls our inquiry is discovery. Myself and my colleagues as attorneys in this area of law and representing charter schools naturally read discovery and paid very close attention to your unanimous voices, your holding, and your guidance. Discovery closed some doors for charter schools who seek to appeal denial of amendments to charters. And that's because the right to do so does not exist in the exhaustive statutory scheme of the charter school law. But in a very positive way, we received something that was needed in this area of law. You gave us certainty. In discovery, you unequivocally confirmed the separation of powers doctrine that forms the foundation of our Constitution. You confirmed that we should apply the fundamental rules of statutory construction, whereby when the words of a statute are clear and free from all ambiguity, the letter of it is not to be disregarded under the pretext of pursuing its spirit, and that we must construe every statute, if possible, to give effect to all of its provisions.
Can I ask you then, what does the letter of at the end mean? Because your argument could be seen as trying to convert that to by the end. When we say you can do something at the end, or you must do something at the end, is that different from saying you must do that by the end?
The preposition at denotes a fixed period of time. For example, Your Honor, if the school district were to tell me, let's meet for coffee at 3 p.m., that means we're going to meet at 3 p.m. It doesn't mean we're going to meet 10 months later. And the General Assembly knew what it was doing when it chose to give finite charter terms as opposed to endless charter terms that could be renewed at the whim of a school district.
Counsel, following up on that, during the term of the charter means at the end of the term as well, correct?
Yes, Your Honor, that is correct.
Why would the General Assembly add 2 distinct terms in the same sentence, and why should we consider the latter to be equal to the first?
Your Honor, that's because the language explicitly states that during or at the end of the term, a school district may choose to revoke or non-renew a charter. That means that there's a finite term, as was clearly defined in other areas of the charter school law, and during that period of time, a school district has a qualified right to choose to non-renew or revoke that charter. Once that period has passed, once that fixed period has passed, that right is waived under the principles of waiver that we express in our brief. And at the end of the day, that's what it says.
Well, at the end of the day, I'm glad you said that. At the end of the day, would that mean at midnight? What about 12:01 a.m., 12:02 a.m.? Could the school district have done this the day after the end? I mean, the end is a passing moment in time, right? So could they do it the next week? Is your argument a matter of degree or a matter of kind?
Your Honor, today is the 27th. At 12:01, it will be the 28th. At the end of today, that's the end of today.
If I said to you, let's meet at the end of the day, and so you were waiting on the corner at midnight, and I showed up at 12:01 a.m., would I be non-compliant?
You'd be late.
Counsel, I have a little different interpretation question. I'm not certain that your reliance and your repeated reference to the term choose really supports the argument that you're making. Because as I read the entirety of this particular section, it makes a distinction between the choice of the school district and a final determination by the board. So if you read this statute and all of its subsections together, I read this to say that the school district must make its choice before the end of the term, but that's not outcome determinative, because subsection F of the statute deals with what happens when there's a final determination, final disposition by the appeal board. So as I read the statute, the school district must make its choice before the end of the term, and then the appeal process runs out, and the statute makes clear that this charter shall remain in effect until the final disposition by the appeal board. So there's a choice, and then there's a final disposition by the appeal board. Why is that not an appropriate reading of the statute?
Your Honor, when the school district, the School Reform Commission promulgated a resolution, SRC 8, directing the hearing for Eastern, they specifically wrote into that resolution that the hearing was for the purpose of making their decision or their choice with respect to...
They're two different words. They're two different words. Choice, to me, choice is a very odd term to use in the context, because it is not the same as a determination. We're making a choice, and then you go through the appeal process, and then there is a final determination.
Well, it certainly begs the question, what does it mean for a school district to make a choice? Certainly a choice to non-renew has the language of finality. You've chosen once you've made that choice. And school district, charter schools have a property right in their charters. That choice to non-renew has no legal import until the processes that are due have been given to the charter. So what we're saying here is that that choice doesn't occur when the processes that are due are engaged. The choice can only occur when the processes that are due are completed.
Except, counsel, the school district's choice is not determinative. An appeal is taken, and the charter school wins. You know, the concept, the idea of making a choice in the context of this entire statute is just not outcome determinative. I could choose, you know, to not, you know, come onto the bench today, but somebody might say to me, it's your job, you have to be here. So my choice is not necessarily outcome determinative. And that's why in reading this in its entirety, it just seems apparent to me that the choice has to mean what that common phrase means. I'm choosing not to renew. Now, you have your appeal rights and all of those kinds of things. Go to it.
That would render the rest of the charter school law absurd.
Why is that?
Because the charter school law states that charters are to have fixed terms. And what I think Your Honor is saying is that the school district will make a choice and then make a determination. That choice in and of itself.
The appeal board will make the determination.
I'm sorry.
The appeal board will make the determination. I mean, that's why I'm saying. I mean, I understand, you know, your argument about the finality of the fixed terms and things of that nature. Except the statute specifically makes provision for what happens if the appeal board hasn't acted on the initial choice. It says the charter shall remain in effect until disposition by the appeal board.
Right, and I think what we're doing here is conflating the fact that a charter school can remain in effect while it's pursuing its appeal rights. That's not disputed here. The issue before the court is, what does it mean? What does 1729 mean when the school district has to make its choice? That we're talking about a local school board making the choice, not the charter appeals board. And that choice can't be perfected twice.
But in the context of a quote-unquote choice at the end of the term, you'd have to read out subsection F, which makes provision for a situation that the appeal board has enacted.
And you're referring to the charter appeal board, Your Honor.
I'm referring to the appeal board that's encapsulated within the same statute that we're talking about.
1729 addresses the school board, the local school district's choice, not the appeal board. The local school district has to make a choice at the end of the charter or during the term of the charter to renew or non-renew.
I agree with you. I agree with you. They have to make that choice and give notice within the term of the contract, within the term of the charter.
That's what we're saying.
Which they've done here. And then the appeal process played out.
The operative event to implicate the appeal process is the decision of the school board not to renew. Is that correct?
Yes, Your Honor, exactly.
That was made in April of 2018.
Yes, Your Honor.
Well beyond the period that we're talking about. So no appeal could be taken until the school board makes its determination, right?
That's
Your argument is that was well beyond the statutory limit for renewing or not renewing. Isn't that correct?
Yes, Your Honor.
Because the charter expired in when, June of 2017?
Correct.
And the school board didn't make the official decision until 10 months later. And then the appellate process started.
That's correct, Your Honor. And
You don't want us to say, you get a year, like this is over a year, right? Or was it 10 months? Remind me.
it was 10 months.
Okay. In other words, you wouldn't say it's principled for us to say 10 months, that's too long, but 10 days, that's okay. In other words, you're saying, pursuant to my question about midnight and 12:01, you're saying if you're a minute late, you're late. You're non-compliant. So, in other words, Justice Saylor's question elicited from you that 10 months is no good, but you would also say 10 minutes is no good, or am I incorrect?
You're correct. We're asking you to apply the same standard that you did to discovery. And if it's not in there, then it doesn't exist. If it's not in the charter school law, then it doesn't exist. And this is a good thing. It'll provide, this ruling that we're asking the court to make will provide the certainty that school districts and charter schools need. Practically speaking, and this is beyond our textual argument, which could be the sole basis of your decision, there's a lot of dissension in this area. There's a lot of legal dissension in this area. And when discovery came out, it was, for charter schools, okay, yes, we can't appeal amendments, but you really did underscore the certainty of going to the text and reading what it says and what it doesn't say, paying attention to what it doesn't say. And when we turn to 1729 and apply this...
May I ask you, before you move on, in that regard, is it your argument that this statute is unambiguous and we don't look further than these words, or that it's ambiguous and using the tools of statutory construction, we arrive at your result?
It's my position that it's unambiguous. One can read the statute and know what it means.
Why? It seems to me that the natural reading is during the time that the charter is ongoing, been granted till the end, that the school district's choice is revocation, which necessarily, if it's revoked, would perpetuate beyond that end date. You're done. You don't have a charter anymore. And that the legislature's choice, again, as they did this, there's a symmetry. The term of the charter, revocation, at the end, non-renewal. And that would really mean that the more natural reading of that is after the term of the charter is when you don't renew. There's non-renewal, because during your election of remedies was revocation. Now, why is that not a common sense reading of this language if it's unambiguous?
The common sense reading of the language is that during or at the end of the charter, the school district may choose to revoke or non-renew the charter. That means during a specific period of time, a finite period of time, meaning the term that's clearly defined elsewhere in the charter school law, the school district has the right to choose. They can choose to revoke, they can choose to renew.
As you read this language, can they revoke after the end of the term?
At the end of the term, they cannot revoke because by its very definition, if there would be a new term and any revocation would have to apply to facts existing with respect to that term.
How long do they have to wait?
Respectfully, why, just one last one, and
I'm
it's
sorry?
all, no, it's all yours. Respectfully, by the same logic, using the same process of analysis, why doesn't at the end of the term mean after the end of the term? And that's when you move to the non-renewal.
Because of the language that says they have to make their choice during the charter term or at the end of the term. And this isn't something that would be unduly burdensome for school districts to follow. It would create certainty for all the parties involved. Under 1728, school districts have a continual and continuous duty to monitor charter schools. They collect all sorts of data on our charter schools. The School District of Philadelphia has an authorizing quality initiative. They have a framework that they apply to charter schools. They issue notices of deficiency. In fact, at the time that Eastern made its application, most of the data that was later used in the school district's potential allegations in SRC 8 was already in their possession. And furthermore, the process that is of hearing that's contemplated by the charter school law is something that can be done efficiently and within the time frame allotted by the term of the charter.
Yeah, I do have a question. If you say this would provide certainty and everybody should comply with the deadlines, obviously that's true. But in the real world, deadlines are missed. Something is not renewed on time, but is renewed or attempted to be renewed 10 days later or 10 months later. What happens in your sense of world order? What happens once the deadline is missed? What can the school district do and what can it not do?
Okay, so I believe that the hypothetical scenario is that the deadline is missed.
Correct.
Under the language as it was written by the General Assembly, once the deadline is missed, that qualified right is waived.
Forever?
It is waived.
Forever.
It is waived it is waived with respect to the term that concluded.
But when does a new term begin?
At the end of the old one.
So it's forever waived. That's
The law permits a one-year renewal. Why would it not be implicitly applied that the renewal was granted for 1 year since operation is still maintained, and then ultimately during that new academic school year, the charter now revoked, the school district now revoked your charter? Why isn't that a rational, reasonable explanation of the school district's conduct pursuant to the statute?
Your Honor, that is a good question. And it really points to the fact that the General Assembly did indeed literally and unambiguously require fixed charter term lengths. The 1 year exception applies to cities of the first class and that is correct for reasons where the school district believes it needs to collect additional academic data. It involves an authorization of a 1 year charter for the purposes of collecting that data. This didn't happen in that case, but it could have happened.
But I'm still trying to, you really didn't answer my question. You shared with Justice Todd that the waiver is in perpetuity. But so the question I had for you is, what's your position? That your charter has been renewed now forever because they waived it, or renewed for 5 years, or renewed it for 1 year, or renew it up until they tell you it's not? Based upon your own argument that it's waived, when do you end?
If it's waived, Your Honor, then the application of the charter school is deemed approved. And that application contains a set date and set request for a term of years. This is a process that is absolutely practical to engage in, whereby the charter school enters into a charter with a school district. It's for a fixed term. And by the end of that term, a choice has to be made whether to renew or non-renew. If it's waived, then what else could happen? Then the charter application is deemed to be approved.
For how long?
For the period of time that's requested in the
How long did
application.
you ask for in your renewal? How long did you ask for in your renewal?
5 years, Your Honor.
5 years. And you filed that in the fall of 16.
Yes.
And then the school district issued its non-renewal notice on June 15th of 17. Is that correct?
On June 15th of 2017, they issued SRC 8, which engaged the hearing process by its very own language so that the school district could make its choice.
Which they knew as well. If your interpretation of the statute is correct, that couldn't have happened in 15 days.
No, it could not, but it shouldn't have happened
I
then.
understand that, but the point is you filed in the fall, and they wait till 15 days before the expiration of the term to start the process.
And that's the case. And to the school district's argument is that the process of ascertaining whether a charter should be renewed or not renewed, takes an exorbitant amount of time, and that's simply not the case.
That's something, if your theory is correct, the school district should go to the legislature and say this thing doesn't work the way the statute's written. Is that not correct? It doesn't give us enough time.
That is correct, and it's correct under the language that you utilized in discovery. Yes, this may be burdensome. It may be difficult to work with, but when I read discovery, it reaffirmed the practice of our craft, which is to return to the text and see what it says, and if it's unambiguous and not susceptible to any other meaning, and if you can interpret it in a way that doesn't conflict with other statutes, then it has to stand.
Does the text specify, and forgive me, I think I'm missing this, does the text specify a date or point in the term by which time the charter has to submit its renewal application papers? I didn't see it, but I might have missed it.
The statute, I believe, does not. I believe that November 15th is the date in the charter school law where a charter can, founders can apply for a charter, but that doesn't preclude school districts from setting that time frame in their capacity as authorizers. They have a significant amount of authority over charter schools.
So supposing the end of the term is, I don't know, December 31, absent some affirmative action or step by the district, the charter could submit their papers on December 30, and if they didn't get a no by the next day, you're automatically renewed. Is that correct?
Hypothetically, yes, but that's not going to happen.
Also,
Sure.
just, although I understand this case, but they could give you, in this case, being frustrated with you, if you prevail today, they could give you immediate notice very early in your term of revocation, non-renewal. And then non-renewal, let's say January 1st your term begins, January 2nd, and it's a 3-year term. January 2nd, they give you notice of either revocation or non-renewal. And based upon this very cumbersome process, in this case that they visited the school 60 times, and that you get a hearing officer, you get hearings, being a creative lawyer, you could appeal every step to the Commonwealth Court or to your trial court, arguing you're not getting discovery, you're not getting due process, you're not getting this, that, or the other. And it's easy in litigation to continue that longer than 3 years. So you could, in every case, through a successful litigation, push that past the boundary and then be renewed again.
That could be the case. However, Your Honor, we do cite in our brief the premise that parties are entitled to equitable relief where legal remedies provided by statute are truly inadequate or incomplete. And while there are many hypotheticals one could throw out there, the best remedy for charter schools and school districts is to give them that certainty of.
If I could just may follow you on that one. I'm somewhat still confused as to your argument as to an unambiguous statute and the renewal within its time period. So factually, your charter ended June 30th of 2017. June 15th, the school district noticed you of 55 problems with your charter such that they would not renew it. Pursuant to the rules, pursuant to due process, you had a hearing which the public could participate. Now, the hearing extended over the renewal date. Why, in your logic, would they want to renew a charter that they have 55 issues with as to not properly providing our children in Philadelphia the free and appropriate education? What gives you that right?
Well, respectfully, Your Honor, they were wrong about the 55 issues. But that.
On the record is they had 55 allegations of having an incompetent charter school, such that they wanted to close it. You were noticed, pursuant to the statute, maybe 2 weeks before the renewal charter. But under your argument, the due process right to have public hearings, to have the parents and the children and yourselves defend against this attack, extended over that renewal date. I'm confused as to how you justify the strict construction of the statute being so unambiguous. What you're saying is despite these 55 allegations, whether they're 1 or 55, you have a right to continue not educating Philadelphian children. That's what you're saying.
Absolutely not, Your Honor. The children and the teachers of Eastern paid their bills and they sent children to college. We argued that at a hearing that began well after the charter term ended and extended for 10 months due to the school district's procrastination. For 10 months, the stakeholders, the children and the parents who come home every day who want their kids to have a better life and really truly believe that they did at Eastern, bit their fingernails waiting for some ambiguous time period in which the school district would finally make its choice. That's not fair. And the General Assembly, more importantly, didn't mean for it to be the case, as we said in Discovery. Discovery Charter Schools argument is the one that's employed here by the school district, that it's unduly burdensome. And I just would ask the court to apply the same response and standard as it did in that one.
Thank you very much.
Can
Ms. Peter?
I just follow up with one other question on the unambiguous nature of the statute? What should we make of the fact that the only time the word choice is used in the sections of the statute that we're dealing with, 1729A, the only time that term is used is in the section that you're relying on, shall make its choice. The remainder of the statute refers to actions by the school district or the school board as either formal action or a decision of the board or an appeal to the appeal board for final disposition. Why is it that the word choice is only used in this one section? Or does it not make a difference?
We should look it up in the dictionary, Your Honor.
Pardon me?
We should look it up in the dictionary.
I'm asking you.
The word
is there a difference between choice and decision and final disposition or not?
The choice of the school district in 1729 denotes literally a final disposition because it's also qualified by the preposition at the end or during the term of the charter.
Except nowhere else in the statute is the word choice used. You know, the choice of revoking or not reviewing is not used in section C. It's the formal action is referred to in subsection C. When you look at subsection D, where it talks about the right to appeal to the local, the board, it says may appeal the decision of the local board to the appeal board. It didn't say choice. I mean, our job ultimately is to interpret the words of the statute, which is why I'm asking you why it is that the only time the word choice is used in the one section that you're relying on.
Well, Your Honor, I know that it's there. And now that we know that it's there, we have to decide what it means. And the word choice does have a meaning. And we can't construe its meaning in any way that contradicts with other statutes in the charter school law. We know that the General Assembly, they had a choice. They could choose to give charters finite terms. Term is defined in the charter school law.
Okay, so your answer to my question would be then choice, formal action, and decision, and disposition all mean the same thing.
In the context of 1729, the decision by the local board of school directors, yes.
Okay, thank you.
Thank you very much.
Thank you, Your Honors.
Peterson?
Good morning, I think. May it please the court, Chief Justice Barr, other justices.
Until 12:01.
I haven't turned around. Okay,
on
all right.
You're
I
early.
may
You're
stand
early.
corrected. Good morning / good afternoon, and thank you for having me here today. I've been listening to the argument, obviously, sitting here, and I think we're conflating a lot of different concepts and principles, so I want to make sure we're very clear. What is in section 1729-A of the Charter School Law, which is the revocation / non-renewal provision, does reflect, and I hate to harp on this choice concept, but discretion of a local board of school directors to start a process, actually two separate processes, and I think that's important, to dictate what happens with a charter. And there's really three different options. One is to renew a charter, one is to revoke a charter in the middle of a term, and the other is to not renew a charter at the end of the term. What I think has been mixed up in this conversation with Mr. Anacarico in the court is that the terms during the term of the charter or at the end of the charter talk about time frames, but they are discussed from the perspective of the start of a process that will last much longer than the initiation of revocation or non-renewal.
That's the one question that is causing me to pause. Under your interpretation of the charter school law, there is no timeline for you and your organization to make a determination. Is there?
There is no deadline by which the decision has to be made because each decision is unique. Each decision is going to involve its own unique set of circumstances.
It could take years for you to determine?
I guess on one hand, it could take years. In this particular case, as you pointed out, Justice Dougherty, it took approximately 10 months because there were an overwhelming number of issues that were presented as part of that initial resolution in June of 2017.
But then following on Justice Dougherty's question, then you're telling us that in violation of the statute, the district did not choose to revoke or not to renew during or at the end, but at some later point. So, you didn't have a situation where the district sent a notice to the charter saying, on or at the end saying, we choose not to revoke, we choose to revoke or not to renew, and we'll send you the papers later, but we're notifying you now, we make that choice. So under your under your interpretation, isn't your candid answer to Justice Dougherty, yes, there is no limit? And if that's the case, temporal limit, and if that's the case, how does that not violate what the General Assembly said?
Your Honor, I believe what I'm saying is that there isn't a deadline by which the process has to conclude. The process is dictated by the circumstances that exist with that particular charter school. Sometimes those circumstances are such that a decision is made prior to the end of the term to move forward with non-renewal proceedings. Sometimes the circumstances are such that the decision is made after the technical expiration of the date of the charter, because there is evidence being gathered. There could be investigations that are ongoing.
What are they supposed to do in the meantime, counsel? I mean, they also have, just like you have a complex organization. Well, they have teachers to pay, they have maintenance costs, they have operating costs, they have budgets, they have planning, they have curricula, et cetera, et cetera, et cetera. And it seems to me that you want to claim there's enough elasticity in the statute that you can just take the liberty of getting around to it when you get around to it, which apparently is what the district did here. And I guess I'm not sure that the legislature gave you that much rope. Would you respond to that?
I would respectfully disagree with you, Your Honor. I don't think the district took this lightly, and I don't think that there is anything in the statute that indicates the intention of the legislature to provide that, what I'll quote it, I'll refer to as a drop-dead deadline, either to initiate the process or to conclude the process.
Well, and counsel, if 1729 doesn't provide a deadline, doesn't provide a mandatory date for the school district to make this decision, then isn't that a question to be brought to the legislature, not to us?
The school district does not believe the statute is ambiguous. The Commonwealth Court, the complete panel agreed with that. They found that the statutory language in 1729 is clear and unambiguous. The CAB, the State Charter School Appeal Board, agreed with that unanimously, as well as the unanimous panel. We're sitting here 23 years after charter school law has been enacted, I guess technically 24. There have been a myriad of non-renewal decisions as well as revocations that have taken place, and this issue has never come up prior to Eastern raising it, even though in many of those cases, those decisions were made after the charter expiration.
Well, and my point is, if that is going to be changed, if that is going to be tightened up, that is for the legislature.
Yes, if the contrary conclusion to the one that was reached by the lower courts.
The fact that nobody's made a challenge before doesn't mean their challenge lacks merit, right? I mean, that would be a strange legal proposition, wouldn't it?
No, and that's not what I'm saying, but I'm saying we have experienced charter school attorneys, so if they felt the statute was so unambiguous that there was a clear deadline by which a renewal had to take place, or a non-renewal, excuse me, they would have raised that.
Counsel, I have a question.
Yes.
2 weeks before the expiration of the charter, you provided them notice of 55 enumerated offenses, which at blush would appear to be in violation of 1728A, the annual assessment as to the progress of the charter. The question I have is, each year, the charter's assessed to make sure that it's a free and appropriate education to the children. Yes or no?
Yes and no. So under 1728, it says that each year there shall be an annual review of whether the charter school is meeting its goals. That is not a totality of a comprehensive review of the total circumstances and operations of the charter school, as including its academic performance, totality of the academic performance. The School District of Philadelphia does create such an annual report that is distributed to all charter schools in the school district. It is doing that.
But I guess the question is, are you telling me that these enumerated offenses all occurred within the one academic year? Or were they throughout the 5 year of its charter, for which there should have been an annual assessment as to whether the charter was meeting its goals?
They were throughout the charter, and Eastern received an annual assessment in the form of an annual report from the school district indicating there were issues, but that report is limited to certain circumstances. 1728 also has the other requirement, which is that at the end of the term of the charter, a comprehensive review is performed of the charter school's operations. We call that the renewal review. That is the totality of the past 5 years, and it's supposed to be the whole term of the charter. Charters in Pennsylvania are for initially 3 to 5 years, or for renewal charters, always 5 years.
Why do you wait to the twilight of the charter school, its ending date, to try to correct with 55 enumerated offenses, knowing it's going to throw that charter school into a spiraling process of agony for parents and children as to whether their school is going to be there or whether they sit next to their best friend in a month or so?
I think that question is an interesting one, Justice Doherty, because I think it actually questions what the purpose of the school district's role is. The school district does not operate the charter school. The charter school is an independently operating entity that's required to comply with all applicable laws, required to perform its own assessments, make sure it is living up to the intent of the charter school law that was set by the General Assembly, including being accountable for its own operations. So your question kind of assumes that the school district is responsible to intervene on a much more frequent basis if there are issues, or to take over the operations of that school, which I don't believe is the intent.
I did not say operation, but pursuant to 1728, there's an annual assessment. Therefore, you're looking to see if they meet the needs pursuant to the requirements of the charter school law, as well as our public education in the city. You're being told over the course of 5 years that there are certain enumerated offenses, whatever they may be. I'm somewhat startled that the school district, in the renewal process, not during the assessment saying correct your issues, during the renewal process, 2 weeks before, said, we're hitting you with these 55 enumerated offenses for which we have to have a due process hearing, and we're going to bring everybody in. But by the way, we're not renewing your charter or extending your charter, and there's no discussion as to the power of the school district to assure that the children in that charter school are getting an appropriate education, free from stress and anxiety other than they occur each day on the streets of Philadelphia. We don't need to give it to them in the classroom because they don't know whether they're going to be there tomorrow. I guess that's my question.
Okay, and thank you. Part of the annual review process through the report that the district issues for all of the currently 86 operating charter schools in Philadelphia addresses some of the components that ultimately are also reviewed as part of the comprehensive review process, including the academic performance. Eastern would have received that feedback and been on notice of those issues as part of that annual review process. I think your question is really more so of why didn't the school district take action earlier to revoke the charter, which is a separate proceeding, similar standards. I can't speak to whether there was any discussion prior to the renewal process to revoke the charter, but there is a more comprehensive review, including an Eastern specific case, and I know this is not technically in front of you. One of the issues with Eastern was the role of Eastern University and whether that role was continuing and they were meeting the requirements under their charter to be the charter school they said they were going to be. That was ultimately one of the findings on which non-renewal was based. That information was collected as part of the renewal comprehensive review process. The district didn't have that information as part of those annual reports because that wasn't something that they collected, nor does the law require them to collect that. I think what...
I ask you a question. What was the status of this charter under the school district's position from, say, July 1st, 2017 to April 2018, at which time the school district voted not to renew the agreement?
At that time, pursuant to 1729F, The charter continued in effect until final disposition. The way that provision, specific provision,
The charter was in effect for the 2017 school year.
all the while the due process proceedings were moving forward under the non-renewal. The charter school was unaffected in terms of its ability to operate, its ability to continue collecting every penny that the school district would have otherwise paid had it not been facing non-renewal. Nothing changed. Obviously, a non-renewal process hanging over its head has an operational effect, but that would be the case for any operating charter school, whether it was before the end of the term or after.
And then when, that's sort of the same question. I don't recall, I don't know that I read the whole act and don't know that I'd remember it if I did. So when in due course you eventually revoke, due process is over, final decision's made.
Not renewed.
Do you, non-renew, thank you, non-renew. So it's interesting. Non-renewed, do you fund to the end of the school year?
The school district under the statute is required to continue funding until the charter school is required to close. So in this scenario, Eastern elected to appeal to the State Charter School Appeal Board. They were funded the entire time that appeal was pending. I believe the appeal board issued its written decision in August of 2019, at which time they were ordered to close and a stay was not issued by any entity, and at which case they no longer were able to educate students. The students went to other placements.
Counsel, we
and
understand
funding
there's an appeal process set forth in the statute, but we have to put that over here because, you know, our question, granted, asks an antecedent question, right? For the plain meaning of what did the legislature mean here? And isn't the most reasonable construction for us to give that the legislature's telling the school districts, tickle your file, put a tickler in your file every year, and make sure on or before that end date that you give a notice that you're revoking or not renewing? Why is that not the most reasonable construction, given that anything else puts us into necessarily ambiguous and unpredictable time periods?
Well, I don't know that the statute or I should say the legislature intended that everything be predictable, because there's other provisions in the charter school law that make it clear that there is a definitive standard by which a local school board must take action. If you look at 1717 on new charter school applications, there's a myriad of clear requirements in there that says by when a hearing must be held within 45 days of receipt of an application, that a local board must take action on a new charter school application no later than 75 days following the date of the first hearing, that if the denied applicant goes to the appeal board, if the appeal board reverses, the school board uses the word shall, grant the application and issue a charter within 10 days of the decision of the appeal board. All of those provisions are very clearly stated in the charter school law. There are no corresponding mandates in terms of a definitive timeline with respect to the renewal process or the non-renewal process. What Eastern is essentially arguing is what I'm going to call a complete nullification of non-renewal. They're essentially saying you can only revoke because that is during the term, and if you don't finish that process by the end of the term, we get a free pass. Notwithstanding the 55 issues, notwithstanding the fact that the State Charter School Appeal Board ultimately and unanimously agreed with the school district, notwithstanding that the Commonwealth Court also agreed with the school district on non-renewal, we get a free pass. What does that say about accountability?
Well, if not a free pass, but you could read it. I mean, it's a difficult case, and there's good arguments on both sides, but the operative language, as everyone keeps saying, is during the term of the charter, or at the end of the term, the board of directors says that's an official action of the school board, may choose to revoke or not renew the charter. Now, if they don't do either, there's an argument to be made that what usually happens, there's a default, and it's renewed by operation of law. It's that simple. So I guess
I think,
I don't have a lot of difficulty with that language, but maybe there's something I'm missing.
Justice Saylor,
You have a choice, and it's during the term of the charter. At the end of the charter, the school board, by action, not notice, but official action, may choose to revoke or not renew the charter. Now, we're confronted with a situation where they did neither, and that's this case.
well, I would respectfully again disagree with that.
Well, the
They,
action of the
they
school
took
board-
action.
Yeah, but that was after the end of the term, so you can't change that fact.
Well, there's no deemed approved language for a renewal in the charter school law. So you don't automatically get a renewal simply because the charter term expires.
Well, I was using that holistically. That's the effect. It's renewed by operation of law.
But I think the General Assembly accounted for that concern by including the language in 1729F. That
Fair enough, but it's,
operationally, practically speaking, the charter continues. And that is the language the General Assembly decided to use.
We understand your argument. Thank you very much.
Thank you very much. Thank you for your time.
Because we have 2 cases left, we are going to take a luncheon break, 45 minutes. Is that sufficient? And apologies for those of you who are waiting, but please feel free to have lunch, and we'll get going again at about 1:50. 12:50. Thank you very much. I've got to fix my watch.
Please be seated. Next argument is Edward J. O'Donnell versus the Allegheny County North Tax Collection Committee, appeal of Borough of Fox Chapel and Fox Chapel Area School District. Representing the appellants is Mr. Christopher Vincent, representing Mr. O'Donnell is Ms. Cheryl Hoppa.
Thank you. Fortunately or nicely, this is a succinct introduction. We review whether a payment received by a whistleblower under the Federal False Claims Act case is earned income under the Local Tax Enabling Act and the Tax Reform Act of 1971.
A very large payment.
Yeah, a substantial payment, yes, Your Honor. No, I was not. No.
I'm sorry.
If I was, I'd probably
He's retired.
Yes.
I'm sorry for that.
Go right ahead.
As Mr. Chief Justice pointed out, this case is to determine whether or not a qui tam whistleblower payment is taxable under the Local Tax Enabling Act. As you'll recall, income under the Local Tax Enabling Act mirrors the definition of compensation under the Tax Reform Code of 1971 and is defined as salaries, wages, commissions, bonuses, and incentive payments, whether based on profits or otherwise, fees, tips, and similar remuneration for services rendered. If you look up all of those items in Black's Law Dictionary, you get kind of a general theme, and that theme is doing something for someone and receiving something of value in return. When you look up the definition of service, it's defined as the act of doing something useful for a person or company for a fee. So the question really is, did Mr. O'Donnell do something for a fee? And obviously, as we joked, he did. He received quite a large fee, $34.5 million. And the question is, did he do something for the government? We obviously submit that he did. I think
Is it fair, in all seriousness, to characterize the Pennsylvania scheme as an earned income tax?
Yes, Your Honor. For the local tax purposes, the definition is actually earned income.
And that may distinguish us from, there were other cases cited where this was included. So for instance, because we all understand it, the federal income tax is not an earned income tax. You can win it in gaming. You can earn it on lawful sell of drugs, and you still have to pay your tax on it.
That's correct. Gross income is the federal definition, which is I think all income from whatever source generated or something along those lines. And this is much more narrow, yes.
Our legislature's given us a much more narrow scheme for these purposes.
That's correct, Your Honor. And they chose to do so intentionally. Other states that have income taxes simply say we're going to follow the federal government and follow the gross income tax scheme. Pennsylvania does not.
No, Pennsylvania paid state taxes on it, so there's no question it's income. The only question before us is it subject to the local earned income tax.
Well, so Mr. O'Donnell did pay state tax on it. That is actually currently pending. There's a case at the Commonwealth Court where they're challenging whether or not that's taxable for Commonwealth Court purposes, or for Department of Revenue purposes, pardon me.
Who's challenging that? He is.
Yes, correct. He had originally remitted payment, tax payment, once he received the whistleblower payment, and when our matter came to light, he actually filed an appeal with the Department of Revenue, and that's currently being litigated.
He reported it.
Yes, correct, Your Honor.
Well, that's how you picked it up.
Match
the tax returns.
We actually, through an agreement under the required by the Local Tax Enabling Act, we compared state earnings with local earnings, and that is correct, Your Honor. We essentially, the earnings reported to the Department of Revenue included the $34.5 million. The earnings reported to Fox Chapel Area School District and the Borough of Fox Chapel did not, and we said, something's missing here.
That's because you have a narrower definition of income.
Well, the definitions are actually the same, Your Honor. Local income under the Local Tax Enabling Act mirrors that, and the definition essentially says income is that of, as defined under the Tax Reform Code of 1971. So in comparing the two incomes and knowing that the definition is the same, we were able to identify that discrepancy. going back to whether or not a service was performed, I think it's important to take a step back and look at the False Claims Act, why it exists, and how a relator plays a role in that act. The False Claims Act was passed in the 1800s, and it was to help the United States government combat fraud that was being perpetrated against it during the Civil War. And essentially, the relator answers the call of the government. The government says, we need help finding fraud, and the relator comes forward and says, aha, I found some. And they file a complaint. And after the successful prosecution of that claim, the relator receives payment. And it's broken down into 3 tiers. The first tier is based on whether or not the information used in the claim is public. So if anybody knows that the fraud is being committed, there's essentially, I believe it's 10% or less is what the relator is awarded. In this particular case, the information was not publicly available. It was only known by individuals working at this financial institution. And Mr. O'Donnell came forward, and because of that, he was awarded 16%. If the information's private, you get a range between 15 and 20%, based on how much you substantially contribute to the prosecution of the case. Essentially, the more work you do in the eyes of the government, the greater you're taking. The last tier is if the government declines to join the case because they don't have to join with the relator. And so in those cases, the relator is allowed to take more. They've essentially done all the legwork from start to finish, and the government rewards them with an amount between 25 and 30% of the claim.
Your theory that he was an agent for the government, is that your sole theory here?
No, Your Honor, it's not. We believe that the Commonwealth Court respectfully created an error when they held that you had to have a nexus requirement to have income. The regulations is where that comes up, because in the regulations, the compensation includes, and it lists all of the items that are in income, and then it says for services rendered as an employee, a casual employee, or agent.
What if the government hadn't joined the suit? Would this be taxable?
Our position would be it would be taxable. Yes, definitely.
What did he do for the money?
If the government doesn't join,
Lend his name to the lawsuit.
if the government doesn't join in the case, the relator prosecutes the entire case from start to finish. He files the complaint, goes through, files all the pleadings, any objections, and is able to settle the case on behalf of himself and also the United States government.
Then how would he? Well, that's a hypothetical, so I don't want to waste your time because the government did join.
The government did join,
But if
correct.
he hadn't joined, I don't know how he would. That would be service rendered as an employer, casual employee, agent, or officer, blah blah blah.
Well, and Your Honor, again, that's
So I don't want to get involved.
no, and that's perfectly fine. Again, that's the regulatory definition of compensation, not the statutory definition that has that nexus requirement.
Can I follow up on that?
Yes.
Although the statute doesn't specifically refer to the agency or employment relationship, isn't implicit in the list of items that are included as compensation either an employment or agency relationship attendant to each one of them, wages, salaries, commissions, bonuses?
Incentive payments,
Well, but incentive payments is what you're hanging your hat on, correct?
or other remuneration for services rendered, which is that big catch-all.
Yeah, I get that though, but I mean, I know that the regulation specifically added the reference to employees, casual employees, agents, et cetera, but isn't that implicit in the specific list of taxable compensation within the code itself?
I don't think so. I agree that there is agency or employees in some of the items listed, but I don't think it's necessary.
But it's in all of the items listed, is it not?
Only salaries,
Wages, commissions, bonuses.
tips, and then incentive payments, definitely not. I think
Why is incentive payments definitely not? That's why I'm just probing this notion that there isn't an implied agency or employment relationship
Sure.
in each of these categories.
so. The example that I will give you is a car salesman working for a dealership. They will receive incentive payments, not from the dealership, but from the car manufacturer themselves. They're not employees of the car manufacturer. They have no real relationship with Ford in Detroit, but Ford's paying them, hey, if you push the F-150 and sell X number, we're going to give you a bonus, an incentive payment. But again, they're not employees of that Ford Motor Company in Detroit. So there are examples where it falls outside of the employee-employer realm, or agency realm even.
Since we have I might as well ask the question that was paramount on my mind after preparing for it. I was struck by how in the world one gets standing in federal court, which is jurisdictional, and that led me to the Vermont agency case, in which the U.S. Supreme Court, to find standing, said, well, these are really damages, and this is a partial assignment for the relator's own benefit of damages. And so then you know, the bright light goes off. These are damages which are not earned income, and you don't prevail. So why doesn't that not?
Certain damages can be held as compensation, Your Honor. Certain damage awards can be.
Well, that's those that parrot earned income, lost income.
Sure. So just as the United States government doesn't give out $34.5 million to anybody, the notion in Stevens was they were trying to, as you say, find standing, Article 3 standing. And they basically said, well, agency here isn't enough to confer Article 3 standing because there's no injury in fact suffered by the relator. And so they came up with this assignment of claim theory that says, we're going to say that the relator is given a portion of the United States government's claim, therefore they have harm, and therefore they can sue. So just as the United States government doesn't give out $34 million for nothing, the United States doesn't give out a portion of its claim for no reason. And the reason why they gave out the claim was because the relator is going to file the complaint, identify the fraud, work with the United States government, and eventually take if the prosecution is successful. And I would point out that opposing counsel uses Stevens to say that there is no agency relationship. Again, the court there said agency isn't enough to confer Article 3 standing, not that he's not an agent.
In terms of trying to find the correct slot to put this in, and I freely would say to everybody that there's no obvious slot, which is why you're here today. Why isn't the damages slot, especially in light of the United States Supreme Court's analysis, the best that you can do here?
Well, again, the damages isn't the payment. I mean, they're assigning a claim and saying we're going to give you a portion of the claim. And notably, the portion of the claim that they're assigning isn't determined until after the case is successfully prosecuted, and after the United States looks at the relator's actions and says, we think you did the bare minimum, or we think you went above and beyond and earned more. So there really is an element of effort put into this. And when you look at the statutory definition, again, the nexus requirement just doesn't exist. It's not there in the statute, and the regulation begins compensation includes, and then it lists these items and provides this relationship. Those are merely examples, and I know the amicus brief really covers that fairly in depth, but it bears repeating that it's not necessary to find compensation. You don't need to have one of these relationships. But even if you don't need to have one of these relationships, agency still exists here, and we cover that. There's a three-pronged test that this court has adopted from the restatements. In the case of Purcell, and it starts out with, is the principle, is there a manifestation of the principle that an agent can do the work for them? Are they going to go in on an endeavor together? And I think the False Claims Act clearly is that manifestation of the government saying we need help. Whistleblowers, come forward and help us out. Identify the fraud for us. The second prong is the agent's agreement to undertake that, the acceptance of that undertaking. Obviously, I think filing the complaint is a clear manifestation of the agent's intent to join in that undertaking. And the third prong is this notion of power, that the principal is to remain in control of the agent. Now, opposing counsel, I think, has inverted the power relationship in their brief. They say that the agent must have the power to bind the principal. That's not part of the test. They're essentially adding a fourth prong that this court has never adopted. But even if you were to agree with them and say, well, we think that an agent does need to have the power to bind, the agent needs to have the power to bind the principal, it exists. It exists in the scheme of the False Claims Act because when the relator files the complaint, he is binding the United States government to act. They have to choose. They have to choose to join the case and take control of it, or they have to choose to not join the case. If the government joins the case, the principal, they take over. They get to file all the pleadings. They get to, and most importantly, they get to choose when to settle, and they get to do that over the objection of the relator. So again, the agent doesn't need to have the power to bind the principal, as opposing counsel argues, but it exists here. And so agency exists here because, again, it meets the three prongs of the test.
It exists here to a limited extent, only up to the point where the government decides whether or not to join the lawsuit. The agent doesn't have the power or the authority to bind the principal beyond that.
Well, again, it's the agent doesn't necessarily need to have the power to bind the principal. It's not part of the test. But I would say that in cases where the government does not join the case, they are going to be bound by the acts of the agent because...
But not in the other situation.
They can still file objections, and right.
It's a limit.
It is limited. It is limited. But again, it's not necessary. It's not one of the prongs of the test that this court has found.
May I ask you, again, and I think it's a tough case. You have, is a compensation, which is where you'd like it to be. But I've heard that it could be a bounty. I've heard it could be an incentive payment. I've heard it could be damages, etc. There's a very well-established maxim in tax law that the ambiguity is construed against the government. Now, as an old trial judge, and our old trial judge is up here, if you have red car, blue car, he said, she said, you say to yourself, who has the burden of proof? That person loses when you can flip the coin. So given that you have all these various theories, why doesn't government lose because of the presumption that the statute is interpreted in favor of the taxpayer and against the government?
Well, Your Honor, respectfully, I don't believe that there is ambiguity here. When you look at the federal court cases where they hold that it's a bounty, if you look up bounty, it's an incentive payment. I mean, you're basically saying to somebody, take on this endeavor and we're going to pay you when you're successful. That's what happened here. That's what happened. That's what the False Claims Act says. It says we need help finding fraud, and if you're successful, we're going to pay you, and we're going to pay you based on the amount you contribute to this case. Now, the regulations do include items such as incentive payments, which, again, is analogous to bounties. So, I don't think that this is a coin flip. I think when you look at the statutory definition, which is remuneration for services rendered, you get there. I do think that you just have to ask, was a service provided? Did Mr. O'Donnell help the United States government in achieving its goal of finding fraud? I think that exists here.
Got it. Thank you. Anything you want to say in conclusion? I think we understand your argument.
Yeah.
You don't even see an ambiguity, fair enough?
No, I believe that is everything, Your Honor. And if there are no questions,
Thank you very much.
I'll turn the mic over. Thank you.
Ms. Upham.
Good afternoon, Your Honors. May it please the Court. My name is Cheryl Upham from Cozen O'Connor, and I am here representing the appellee, Edward J. Donnell. I will just start out by saying that I do, obviously we're here because there is an ambiguity in the statute. This is an earned income tax case, has already been explained by opposing counsel. Earned income is definitively tied under the Local Tax Enabling Act to the definition of compensation under the Tax Reform Code. Just to go to Justice Saylor's question earlier, there is a personal income tax case that is also pending. Mr. O'Donnell's accountant incorrectly reported the payment as compensation. When Mr. O'Donnell received the payment, he came to us and we said you shouldn't have paid personal income tax. The personal income tax is unique. You can't just follow off of federal. There's no catch-all. You have to really look at, is it compensation? We said you shouldn't have. We filed a refund. And the case, just to be clear, the case of Commonwealth Court is not our appeal. It's the Commonwealth's appeal. The BF&R unanimously agreed with us that Mr. O'Donnell was entitled to over $1 million of a refund because they specifically found that Mr. O'Donnell did not receive compensation. He was not an agent. He was not an employee. He did not render services. He was a co-plaintiff with the government who was looking to enforce his legal rights provided to him individually by the Federal False Claims Act and to receive a portion of the damages, and that's what these are, damages, court damages, paid by the defendant. Now, it came...
let's stop there for a moment, because that's an assertion that I think ought to be probed. Mm-hmm. If this is not an incentive payment, tell us what is an incentive payment.
Based on the definition of compensation, again, it's an incentive payment for services rendered, and I think it goes back to what Justice Donahue said, is that there's an implicit relationship between the payor and the payee. So I'll give a perfect example, and it's actually a case that opposing counsel cited to, which was the Marshland case, right? And the issue was stock options. So those are basically incentive payments. Do better, right? You're do better. And Marshland was an employee, and they were stock options given to Mr. Marshland as an incentive to do better, to do the best he can as an employee. To me, that's what an incentive payment is. It's everything that is in the definition of compensation: salaries, wages, bonuses, tips, incentive payments. They all go to an employer-employee relationship or an agent, relationship, agency relationship.
So it doesn't
none of which was
then,
here.
It doesn't matter to us. It shouldn't matter to us that quintessentially what the government's been trying to do here since 1863 is to incentivize people to blow the whistle on practices like these, and that the Congress determined that they're going to get an award for that.
Well, I think what they wanted, what the purpose of the Federal False Claims Act was exactly what the Stevens case said. They gave legal rights to the relator as an individual, separate and apart from the United States government. When they file that suit, they're filing it for themselves. Yes, they have to name the United States government, but the United States government isn't even a party at that point in time. There's a U.S. Supreme Court case, U.S. versus New York, that says the government isn't a party until they look at the case and decide whether or not to intervene. And again, I appreciate Justice Saylor didn't want to get into it too much, but if they don't, then the relator continues with his case. It's his case. He is a plaintiff in the case.
Who's the check made out to?
Who's the check made out to?
Yeah, when there's an award. Is it made out to the government, who then cuts a check to the relator?
It is made out to, this was a settlement payment, and under the terms of the settlement payment provided that Mr. O'Donnell was entitled to a percentage of the award. It was, and again, all of this was approved by the court, was entitled to a percentage of the damages, and that the payment, yes, would be made to the United States government, and then they would get it. But
you deny that's any kind of incentivization scheme?
I deny, well, I don't want to use the word deny, but I don't think it falls within the definition. What we're looking here for is were services rendered, and I do not think that just because the check was made payable to the United States and he then got part of it, that it means it was an incentive payment. And I think Stevens goes right to that. If I could read a section from Stevens, it would perhaps suffice to say that the relator here is simply the statutorily designated agent of the United States, in whose name the suit is brought, and that the relator's bounty is simply the fee he receives out of the United States recovery for filing and or prosecuting a successful action on behalf of the government. This analysis is precluded, however, by the fact that the statute gives the relator himself an interest in the lawsuit and not merely the right to retain a fee out of the recovery. He's a co-plaintiff. I don't know how it makes it any clearer than that. He is a co-plaintiff. These were his share of the damages. And I go,
excuse me,
yes.
Who makes the decision as to what percentage Mr. O'Donnell received? Whether it's 0% or 20% or?
Well, the statute gives a range. Again, my opposing counsel went over the 3 tiers. The statutes give a range. The government will make an initial determination, but in the end, it still has to be approved by the court.
But it's the government who gives the recommendation.
And then the court decides whether or not it is fair that he's receiving a certain percentage of the damages from the defendant.
And is the basis for that determination by the court whether he earned it?
Well, again, but you could say that anybody prosecuting a lawsuit earned. I mean, you don't just walk into court and say, "Hey, somebody did something. Give me some money." You have to prove your case, and he did that. Again, he did that as a co-plaintiff, not as a service provider to the government.
Well, counsel, is that true when the government takes over the case? I mean, what kind of service does a relator have to provide? I mean, isn't the provision of a smoking gun one piece of information? Wouldn't that be sufficient?
Sufficient for
as a predicate for a key tam action. I have the document that establishes that this drug company knew that they were selling poison to children.
But I still don't think that's providing a service to the government. Again, I think he was given the legal right to act as a co-plaintiff with the government, and that is his basis for initiating the lawsuit in his name.
My example may prove your point.
Right.
Because there's no service involved there.
There's no service.
Provision of information.
Exactly. It's provision of information that allows him to proceed as a co-plaintiff.
Your opposing counsel, in response to my question about why isn't this an incentive, or he gave an example of a car salesman who gets a payment from Ford Motor Company, and he or she is not employed by Ford Motor Company. Is that a correct analysis?
I don't believe so. I think in that case, if he were to receive, if the car salesman were to receive an incentive payment from other than his employee, it would not be compensation. I'm not saying that it wouldn't be taxable under PA PIT, but it wouldn't be compensation. It would be business income, because they are acting in their own, as a business. They are operating a business open to the public, to all of the car dealerships or the car manufacturers. This is a question: is it compensation? Is it for services rendered? And going back to In re Husband's estate, there is significant ambiguity here. And I think that, it's not for services rendered, it is not compensation, but if there is any ambiguity, it needs to be decided in favor of Mr. O'Donnell.
Thank you.
Was your firm counsel to what?
No, like you said, I would be retired if we were.
I realized I asked the wrong person.
Yes, no, we absolutely, no, we didn't
have a conflict.
We did not come in. We are just tax counsel. Yeah, we don't make good money. We do okay. Absolutely. Thank you.
They already have one, so yeah, the Commonwealth Court has it, though. They're going to affirm it. Yeah, they're going to affirm it. Sure. Yeah. Well, which is, of course, why the
This case involves the termination of father's parental rights. It's undisputed that father last saw his 2 children in January of 2016. He argues this was because of his addiction to alcohol and that he exhibited reasonable firmness in his attempt to overcome his addiction and should not be found to have refused or failed to perform parental duties for the 6 months immediately preceding the filing of the termination petition. Father also argues that the Superior Court substituted its judgment for the trial court when it reversed the trial court and terminated father's parental rights. Ms. Whalen?
Good afternoon, Chief Justice and Justices. We are very happy to be before you, so thank you for affording us that opportunity. The central question, I think, in the case is how the Superior Court, the trial court, and ultimately the 7 of you view alcohol addiction. It seems to me that the Superior Court's decision was fairly flip about it. I particularly cited in the brief the use of quotation marks by the Superior Court around the words chronic alcoholism and debilitating alcoholism. And to me, that indicates a complete misunderstanding and failure to appreciate the nature of addiction. The Superior Court then goes on to liken that to Mr. Kalich, my client, waiting for a more convenient time to exercise his parental rights. Because the record shows he filed a petition to modify custody 8 days before mother filed her termination petition. He had been sober for a year. He waited for a year because he didn't want to be in and out of his children's lives while he tried to rehabilitate himself from his alcoholism, which alcohol usage began at age 13. And it's the nature of the addiction that you have relapses, you have recoveries. He testified he had approximately 15 admissions for rehab and detox until finally in October of 2018, he managed to start his path to sobriety, which he has maintained.
Counsel, I don't mean to derail your argument, but we're very familiar with the facts. I don't think we took this case to determine how we should view alcoholism as much as we took it to determine if the Superior Court substituted its judgment for the discretion judgment of the trial court. So
respectfully,
I think
Your Honor,
that's where we're focused.
Well, I think those things are kind of tied together because the trial court found the overcoming the obstacle of addiction to be the explanation for the absence of Mr. Kalich from his children's lives. And 2511A1 is clear. Once you find that there's been the cessation of contact, which obviously we've had, then you have to look at the explanation. And then you have to judge the explanation by how the parent, in what circumstances the parent found himself. And that's what the trial court did. Now, the Superior Court did not. And the Superior Court's job, as you all know, is not to look for evidence in the record to find a different result. Their job, Chief Justice, you're shaking your head.
And actually, I view the case differently than my esteemed colleague. When I looked at this, there are no facts in dispute. The question of whether your clients use reasonable firmness to overcome the barrier to parenting is a question of law. Now it's a mixed question because you need some facts before you can answer that. But it seemed to me that all the facts that matter are undisputed. It's undisputed that he hasn't seen the kids in 5 years. It's undisputed as how old they are. It's undisputed that unfortunately he has had a terrible alcohol addiction. It's undisputed that he's overcome that addiction. So I didn't see any facts in dispute at all.
I would agree with you, Your Honor, and it has to do with the interpretation of it. The trial court interpreted those facts one way.
Right, so it's a question of law. And did the Superior Court make a mistake of law when it refused to find that alcoholism is a justification, if you will, for not seeing your children?
And the answer is yes.
Okay, but it's a question of law, so let's proceed from there.
Yeah, it's a question of law. I mean, clearly there are facts. This is one of those issues which I think I cited in the brief as it may be a close call either way. But the scope of review for the appellate court, as you all know, is, as I said, not to look for facts to support a different result. It's to see if there is anything in the record that supports the decision of the trial court.
Well, in this case,
some ways, I'm sorry, I think we're saying the same thing. It's about the departing of the standard of review, departing
Yes.
from the standard of review.
although the standard of review on a question of law is plenary and de novo. We can find that the Superior Court made an error of law. The trial court gets to decide the facts. But since you and I agree that the facts are undisputed, we have to make a de
With
novo
all due
decision.
respect, Chief, I think the question before this court is very specific. It's a substitution of judgment. It's not a matter of a question of law. We could always deliberate this in the back, but the way I see it, I have to articulate that I'm in agreement with Justice Todd, that the question before this court is, while alcohol's the issue, did Superior Court substitute its judgment because it disagreed with the finding? It should have been abuse of discretion or an error of law, not a de novo review. That's how I see the.
But if I could jump in now as the fourth person.
We're gonna vote while we're here.
No, let me just say that.
I'll just wait.
That unlike, I suppose, any of my three colleagues who have spoken to it, in my view, what's interesting about this case and why it was Aplts worthy is the alcoholism question, the treatment that our courts give to the alcoholism. And I'm especially interested in asking both lawyers, or having both lawyers address whether, and if so, why, a parent's struggles with alcohol and attempts, fitful if they may be, at sobriety are treated differently in a private TPR petition than in an agency-initiated TPR petition, when this would be part of a permanency plan, and parent, here father, arguably might get credit for steps at sobriety. See, that to me is what why this case is different from a run-of-the-mill, did you substitute your judgment for the trial court, et cetera. So anyway, long story short, if you could comment on that once you've done commenting on my colleagues' questions.
Let's keep Justice Weck's question right there, and he can certainly rephrase it or remind you what it is. Let's forget the balance of it. That's why you can see, and everybody watching this case, how seriously we take it. And when the time comes, you may well get 3 or 4 opinions on that, because reasonable jurists can differ on this. So let's forget that, and let's go to Justice Weck's question.
A couple things occurred to me in response to your question, Your Honor. I mentioned this in the brief when I was doing the research. There is a total dearth of cases in the private termination setting. The 2 that I found that were closest to my fact pattern are non-precedential because they were published prior to the year that I'm allowed to use them.
You're allowed to use anything with us.
Thank you.
We're not bound by the Superior Court's rules.
Okay, that's good to
Also
know.
has
Thank you.
persuasive value, but no
Persuasive.
stare decisis.
Okay, thank you. And 2 of them were almost exactly like this. The LMM and the LSGL, I believe was the case. And same fact pattern. The first one, the LMM, the guy had an alcohol problem. He was a veteran in Butler who ultimately got into Veterans Court in Butler and rehabilitated himself and was able to defeat the termination of his parental rights when his ex-wife stopped him from seeing his children while he was still not sober. And then when he rehabilitated himself, that evidence was accepted by the trial court and his termination was denied. The other one was a case from Bedford, and the woman actually had an advanced degree. She had a master's degree, and she fell into an abusive relationship with a guy. She developed an opioid addiction and an alcohol addiction, and it was a family member who was awarded custody of her daughter pursuant to a dependency proceeding. It took her several years, but she rehabilitated herself. She was able to defeat the termination. So I think, first of all, there are not that many cases on point, certainly not in the private setting. In the dependency setting, you are exactly right, Justice Barr. He would receive credit.
Justice Weck, but that's okay. You're on a
I'm
roll.
sorry. I'm looking at you, and I'm thinking about him. Thank you, Justice Weck. See, was that an incentive? Was that an incentive? It may have been. Okay, all righty, it'll depend on what you decide. But my client would be rewarded in the dependency setting because we all know the rule. If your children are in the custody of the agency, you have to jump through all the hoops that they set before you to get your children back. The other issue that distinguishes the private case from the dependency setting is permanency and care control and nurturing of the children is really not an issue because the children in this case were at all times with their mother. So they were never without one parent who wasn't providing for them, unlike the situation in many dependency cases where you have no parents who are able to provide for the children and then the children are in placement. So here we had one parent who always had the children, who always cared for them, and then we had a stepdad move into the situation who assisted while my guy was off experiencing the relapses that occur with the addiction. So the children were never at risk, as is the case with dependency proceedings. So I think that's a little bit different too. Justice Barry shaking your head.
Again, and I agree with my esteemed colleague, Justice Todd, on this point. The case is not how you view alcoholism, respectfully. You can substitute drug addiction. You can substitute mental health difficulty.
Exactly.
You can substitute incarceration. You can substitute poverty. And the question is, what constitutes reasonable firmness in to me, again, and we may have disagreements, what constitutes reasonable firmness in overcoming your impediment to protect your parental rights, which requires affirmative conduct. My goodness, we all know how hard, I assume you included, it is to raise kids. And the difficulty here is, I mean, he breathed, he ate, he slept, he did whatever he did without a card, without an email, without a telephone call, without anything whatsoever. I mean, the record's undisputed that neither of these kids would recognize him on the street and know who he was. And is that notwithstanding, and I have empathy for his alcohol addiction. I'm sure it's real. But does that constitute reasonable firmness? And I think that's what you have to answer. And that's under that's the statutory language.
Well, even before that, Chief Justice, the question is, the trial court found it was reasonable firmness. So it is
You're gonna drive us right back into this law or fact rabbit hole, but go ahead.
Well, it kind of is the rabbit hole. You have a trial court who sees the people, judges their credibility, listens to the evidence, determines what he is going to rely on and what he is not going to rely on, and he makes the decision. And the case law is clear, is that he is accorded the same difference as if it were a jury trial. Therefore, you look for manifest unreasonableness, ill will, abuse of discretion, none of which the Superior Court found. So the question really is not what is our intellectual debate about whether it is reasonable firmness, but is whether or not there is evidence in the record to support the decision of the trial court who found it to be reasonable firmness.
But and to further ping pong with my colleagues here, I take it that a big part of your argument is that the Superior Court's error, in relevant part here, is that it did not consider his averments of struggles with alcoholism in the same way that our courts consider the other barriers the Chief Justice was referring to, like as struggles with drug addiction and the other struggles people's encounter, that the Superior Court was unduly dismissive of the viability of that. And that's why I asked the question in the agency petitions that some of us have dealt with many times, struggles with alcoholism, a sobriety plan as part of a permanency plan, that all gets trotted out. But under the Superior Court's rubric here, as I take it, a claim of struggles with alcohol is relegated to, at best, a second-class citizen status.
To me, the reading the Superior Court opinion, as far as they were concerned, he could have been traveling the world spending a lotto earnings because he was waiting for a more convenient time, as opposed to a person who was struggling with addiction. Now, it seems to me that if we did have a drug addiction, to opioids or heroin or, pick drug of your choice, or if we had a serious mental health situation, as some of the cases that I've cited, there was the one where another person with a master's degree had a significant mental health problem, and it wasn't for 2 years till she went on Haldol that she became stable and was able ultimately to defeat a termination of her rights. But if it were one of those things, which is, I don't mean this to sound the way it's going to sound, but I have no other words. If it were something that was less socially acceptable than is alcoholism, because who among us doesn't go home and have a glass of wine or a beer? Okay, Justice Todd does not. Okay.
She's the only one who
Chocolate, chocolate, buttercream icing instead. Okay. If we all understand the drinking of alcohol perhaps a little bit more than we understand injecting heroin in our veins, or smoking a crack pipe, or even have paranoid schizophrenia. So those things, to me, from the tenor of the opinion from Superior Court, those were, as you say, accorded a different level of treatment than something, for lack of a better phrase, so garden variety as alcohol. Yet it is no less addictive.
Counsel, that may be so, and perhaps somebody here could write that narrowly. But my concern is you jeopardize adoption law. Let's use your example. The person's active military, and he is overseas all the time, in war zones all the time, in peril all the time. He could be special forces, Green Beret, if we still have those and the like. And he makes the decision that until I get out of the service, I am not going to have any contact whatsoever with my kids, because I don't want to traumatize them that I'm here, I'm gone for 6 months, I'm here, I'm gone for a year, and I might get killed over there, given what I do, and think of that trauma. So I just won't talk to my kids for the 5 years till I'm safely out of the services. If we decide this in your event, forgetting whether we have empathy and understanding of the debilitations of alcohol, isn't that perfect precedent that gentleman, that armed services forces, use reasonable firmness to overcome?
Well, I don't think that's analogous, Your Honor, with all due respect. First, for the obvious reason that you're probably not going to be able to serve him with the termination, and then he's going to have rights to show up for a hearing. And presumably he'd have to be divorced or not married, and presumably there'd have to be a new step-parent in the picture who wanted to adopt. So unless we had all of those facts, I wouldn't.
Your client had 2 orders.
He did.
From court, giving him permission to see the kids, and didn't take advantage of either of them.
He did not. And as I said in the argument at the trial court, when you're a hot raging mess of an alcoholic who doesn't know where he's going to be sleeping or exactly where he's going to be eating, and whose only thought is alcohol, you're not thinking about going to the Hallmark store and buying a card to send to your children.
Okay, thank you.
Counsel, I have one question. If you were to adopt the fact as a matter of law that sobriety helps form a settled purpose, what happens to the scenario where dad's or mother's a raging alcoholic, is sober, but refuses to contribute to the care and necessity of the child?
I'm a little confused about the question, Justice
The question
Dougherty.
is that there's been a position that maybe we should take as a matter of law, that sobriety it will overcome that unreasonable firmness argument, that we can beat the statute with sobriety.
Well, here's where I'm confused. Isn't sobriety overcoming the obstacle? That's why I'm confused.
So the question becomes, you could be sober and still not want to be a parent, so. Yeah.
Oh, sure, you could be sober and still be a butthead, no question about it.
The question
They're not mutually exclusive.
The question becomes one, this issue before us is only addressed under 2511A1.
That's correct. That is correct.
That's my concern.
No, that's exactly correct, because you don't reach the other parts of that statute until you get past the requirements of number 1, which is you have to look at the explanation, you have to judge the parent in light of the circumstances in which he found himself, and to translate that would be walk a mile in his shoes. And the trial court did that. Superior Court did not, and I remember when we all started law school in my class in 1978, and the judge would say, why do you think that was the opinion, we would say innocently, because that's the answer the judge wanted. Well, I feel that's the answer the Superior Court wanted, so they looked for all of the evidence that supported their thoughts and did not look for the evidence that supported the conclusion of the trial court, to whom great deference is to be given because he's the guy who heard everybody, he's the guy who weighed the credibility.
Counsel, you've sort of led into a question I have, but let me ask you a question about the record that I think I'm clear on. Wasn't it established that the mother agreed that the father shouldn't have contact with the child until he was sober?
In this case?
Yes.
I cited a case that was exactly that. In this case, there was an order that said he should not have contact until he had supervised contact. Way back when, in this case, shortly after the separation of the parties, and I want to say 2016.
Okay.
So I wouldn't go so.
Very young children at that point.
They were.
You had an alcohol as a problem, which he conceded. So the trial court
correct.
said he could see his kids, but he needs supervision.
Way back when, yes, that is correct.
Okay, but let me ask you another question, because I think some of my colleagues are elevating what the Superior Court actually did in this case. Because as I understand what the Superior Court did here, as I read the opinion, is that they did a de novo review of the record, did not engage in the analysis that the trial court engaged in, and reached its own conclusion without ever addressing the predicate issue that we've all been dealing with here today, which is the effect of overcoming alcoholism for a sufficient period of time to establish sobriety.
I would agree with that. As close as they got to that was stating my client waited for a more convenient time.
But that's not engaging
It's not.
with the trial court's analysis. It's
It is not.
based upon a de novo review of the record, irrespective of the mixed legal and factual conclusion that the trial court reached in this case. Instead, they read the record and came to a different conclusion.
And that would be substituting their judgment for that of the trial court. I would agree with you, Justice Donahue.
Thank you very much.
Thank you.
Hear from opposing counsel.
Thank you, Justices.
Ms. Lovelace.
Chief Justice, may it please this honorable court, Ashley Lovelace, counsel for the appellees AG and BG. There's been a lot of discussion about what the primary issue in this case is, and the appeal that's before this court is based on whether or not the Superior Court did in fact substitute its judgment, and we have a lot of interrelated issues as far as chronic alcoholism and whether or not that justifies not performing parental duties, not just for 6 months, for over 4 years. And I think that, Chief Justice, you're correct. This is an oddity, I believe, before the court, because this isn't a typical private or dependency case where we have an agency saying, well, Mom and Dad, you did 1, 2, and 3, but you didn't do 4, 5, and 6, where it could be a matter of interpretation. This is a case that literally no one on the case, including the trial judge himself, disputed the facts. The trial judge even made a comment on the record that I know what's happened here. There has been no contact for over 4 years. There is no dispute of the fact. The problem is in 2511A1, when you're looking at it, I mean, obviously the facts are what they are. The facts are uncontested, undisputable. Then we look at this barriers argument. And the case law is clear that you can't preserve a more suitable or convenient time. And I'm not trying to diminish the severity of alcoholism or mental health, drug addiction, housing issues, any of that. A lot of these parents are suffering from multiple things that would serve as a barrier. It could be something as simple as losing a job and can't find a suitable home or enough bedrooms for your children. I understand that, and I'm not diminishing that. However, you have to exercise reasonable firmness in overcoming these obstacles.
See, that's correct as a proposition, but I want to jump in there because it seems to me that you are now conceding that that's something that a reviewing court ought to weigh. And oddly enough, it's conceivable to me, and I'm obviously haven't been into the certified record yet, but it's conceivable to me that the Superior Court was its own undoing, because there may well have been ample grounds to reverse the trial court. But then when the Superior Court premised its ruling in part on poo-pooing the idea that alcoholism can be a barrier, and basically scorning the idea that there can be such a thing about struggling for sobriety in this context, it cast the whole appellate ruling into doubt. So let me put to you the same question I put to your opposing counsel. Is there some reason in your judgment why our courts should address these struggles with alcoholism differently in private TPR petitions than in agency petitions, when it would be part of a permanency plan and we'd have review hearings where we'd consider parents' struggles with sobriety and how they're doing? I assume you're familiar with how that works.
I am, Your Honor.
So can you address that?
Sure, Your Honor. In fact, I do both private and dependency cases through my practice. And I will say this, I believe, honestly, at most levels, a lot of these issues, including alcoholism, are looked at the same. I've done a number of private terminations as well that have not resulted in appeals to this level, but have resulted in appeals as well as dependency. The difference in this, and I can't speak for the Superior Court and what they believe or how they viewed the alcoholism as a barrier. In all of the other cases, nearly all of them, most of them dependency cases, you're looking at a framework. It's never just one issue. It's never just alcohol. It's never just mental health. There's usually parenting and visitation where they progress through. This case, the facts that are undisputed is there wasn't even an attempt. So I think the alcohol and the barriers, that's almost a secondary issue in this matter, because the fact of the matter is the undisputable fact that he testified that he's been sober since October of 2018. He still didn't even attempt a phone call, a letter, a visit, and he had more than most do, certainly more than the dependency litigants have. Their visits are at the discretion of the agency. If the agency doesn't like what they're doing or doesn't like something they heard, they could very well pull their visits or decrease them. This man had a private custody order that granted him specific periods of time with his children. He chose not to. And by his own admission during the trial, I've been sober since October of 2018.
But counsel,
Still nothing.
How many of those scheduled visits were after his claimed date of sobriety?
He never scheduled one. The way that they work the supervised visits in that county is that they included a provision that father shall have supervised partial physical custody through this X, Y, and Z agency. They gave them, they give them the number to contact. There is never, and then they call the custodial parent to arrange schedules. It never took place, and that was undisputed.
I'm sorry, was that opportunity given to him before or after his claimed date of sobriety?
That order, he has had that order since March of 2016.
counsel, he had initial order in March 2016. He's in the throes of alcoholism. He doesn't meet any of his requirements. He moves to modify that order on October 23rd of 19. Mother and stepfather moved to terminate, October 31st.
Yes, Your Honor.
The question becomes, under 2511A1, did the parent, by conduct continuing for a period of at least 6 months immediately preceding the filing of a petition, either evidence a settled purpose of relinquishing parental claim to a child, or has refused or failed to perform parental duties? Share with me what's the basis for the moving of termination of parental rights, 4 days after the modification? Why not move termination in 2016-17, coupled by the fact that he's testifying that there is evidence that he wants to be part of his child life. He never refused to be with the child, nor did he fail intentionally to have contact with his child. He knew it was in the child's best interest not to be part of the child's life for obvious reasons. So share with me how Superior Court got it right when the statute reads exactly what it does.
Well, to address the petition for modification, Your Honor, there was ample testimony at the time of trial, and those were also contained in the record, that birth mother and the proposed adoptive father had this in the works for months prior to the actual filing date. They were waiting to get married. They had a wedding planned. Thereby, they didn't have to also have a home study. It would be a step-parent adoption. They had the process in motion. The paperwork was actually, ironically, exchanged through our children share a daycare. So we had exchanged paperwork so that the mail didn't lose any original documents. And that is, it basically passed each other in the mail, and the testimony was reflected on the record. My position would be, he had the order. In order to modify a custody order, you have to attach a copy of your old custody order, which he did. It was still valid. An order remains an order until it's changed or modified. He attached it to his petition to modify. It provided for supervised custody, and he would absolutely be able to enforce that order if a supervisor called birth mother and said, hello, father wants to visit. The modification, I believe he had an attorney get involved around the same time.
The question, did he file pro se?
I believe so, and the old order was attached, Your Honor. So he did also have that.
But that, I apologize. That still defeats your line of questioning. Share with me how 2511A1 is met.
I believe it's met, Your Honor, because the conduct continued for 4.5 years. A mere filing of a petition to modify an order that's been in place since 2016 that's never been utilized. I don't believe that would be contact, that it's just, I want to bring myself before the court to see what I can
So you don't believe in reformation of individuals who have ailments?
I absolutely do. And like I said, I do dependency matters. And I have fought for litigants that suffer with some of these issues. And I absolutely am an advocate. But where does it end? Do we let this go on until a child is 16 years old for someone to say, hey, finally I stopped my bad behavior and I really, really want to reform myself? At that point, I mean, how far does it go?
It goes to the point possibly of seeing if there's some truth to that reformation. Otherwise, we'd have prisons filled with people because they can't be reformed, because how far can they go? They committed one crime once, let's keep them in jail. It doesn't make sense to me, but I understand your position.
Counselor, I'm sorry.
Go ahead.
Counselor, when we decide this case, once we agree, or a majority of us agree what the specific issue is, once we write this case, it is going to impact not just, your two clients, but it's going to impact the children in Pennsylvania. I mean, we're going to be making a decision about how parental termination can be ruled in Pennsylvania by trial courts and by appellate courts. But we cannot ignore entirely the practical effect that our decision will have on you, on your clients, on these parties. And I just wanted to make sure my understanding of how this unfolds is correct. If we affirm the Superior Court's ruling, which affirms the termination of parental rights, we will be affirming that the father no longer has anything to do with these children, and that the children can be adopted by the stepfather, despite the fact that we don't know what has happened to the father or to the children in the past 1.5 years since the trial court's order was entered, and we have no idea what his sobriety status has been for the last 1.5 years. Whereas if we reverse the case and send it back to the trial court felt termination was not in order. He denied the petition for involuntary termination. That does not preclude the trial court revisiting the case and seeing what has happened over the past 1.5 years to formulate a decision that would be relevant today and in the next 6 months and in the next 6 months. So I'm just pointing out and asking you if I'm correct in the consequences of our decision regarding which way we go.
I certainly understand that. And with all due respect, I believe to my clients as well as Ms. Whalen's client, I don't think they're the primary focus in these cases. These children are.
Absolutely.
Who absolutely, and by the record, the youngest was 10 months old the last time she saw him before the filing of this petition.
She's 4 or 5 now.
And yes, I believe she's 5, she'll be 6 soon. And the oldest child, by all testimony and all accounts, had a vague memory referring to him, I believe, as old dad, but couldn't pick his picture out of an album. They have had the stability and the love and the care and the intangibles as required by law that were provided solely by birth mother and stepfather. And I keep going to the fact that, you know, if we accept the facts as they are in the trial court, and he says he's sober in October of 2018, not call, not send a letter. And something stood out to me at the trial court level when the guardian ad litem for these children, who met with these children, made a statement. I've seen prisoners in state prison on life sentences that have managed to put together a handwritten letter or card and send them from jail just because they're thinking of their kids and they want to make an effort and they're trying anything within their power given their constraints and their difficulties to do so. I believe that it's in the best interest of these children for the rights to be terminated. I believe that there's too much history in this, and I don't believe that father exercised any reasonable firmness whatsoever. And I hate to leave the children in limbo where they see father, he falls off the wagon, we have to refile again, we see what happens there. This could be a perpetual cycle for these children.
It just, for the, I'm sorry.
But then again, he may not fall off the wagon.
That is very true.
So,
it's very true.
But the trial court, in addition to all of the reasons stated about overcoming an obstacle and deciding that termination was inappropriate, made its specific finding that it was not in the best interest of the children to end their relationship with the paternal grandmother. Is that wrong? I mean, as I understand the record, the paternal grandmother had a significant, long-standing relationship with these children, including watching them on a daily basis until the petition for modification was filed.
Yes, and there were other circumstances as well, I believe, that came out on the record as far as contact. But the way that the Superior Court analyzed this, and it determined it was an abuse of discretion in finding a relationship, is that there was no testimony that there was any actual relationship with father, who is the subject of this petition.
But I'm asking you a different question. Is the trial court correct in considering the impact on the children in terminating the relationship with the paternal family? Because that was certainly part of his consideration.
I believe it was consideration, but I would respectfully disagree that that would be in line with the law. I believe that the primary consideration as far as 2511B goes to the children, and whether or not the termination of that parent's rights would be in their best interest and is beneficial to them, and also needs to consider the intangibles such as love, comfort, and security. This is solely based on the parent being terminated as opposed to the family.
My turn. It seems to me that, if I remember this correctly, there was both counsel to the children and a guardian ad litem to the children. They both supported termination of parental rights. Is that right or wrong?
That would be correct, Your Honor. And they both met with both children at separate times.
And I don't recall the trial court opining to best interest. Did the trial court, in fact, opine that they were both wrong and that the best interest of the child was served by no termination?
Not to my knowledge, Your Honor. In reviewing the trial court's opinion, since it's been some time, I did review that in the last few days. I do not remember any comment to either the children's attorney or the guardian ad litem in their position.
Which, isn't it correct that it would be legally correct to never get to be, because you don't consider best interest unless grounds for termination are already proven?
Well, the trial court opinion, Your Honor, had actually gone further, where they said even though we're denying 2511A1, we're still going to go to 2511B and just provide an analysis. And that was also addressed in the Superior Court.
And what did the trial court say, if you remember? If you don't, we can go I can read the opinion. I probably did read the opinion and don't remember.
The trial court opinion, the gist of it is that, the petitioners had asserted that that the children do not have a relationship or a necessary and beneficial bond that needs to be preserved, as it is with their biological father. The trial court had written about the testimony that the oldest child
Well,
referred to as
you
old
know
dad.
what? We can read the opinion, so I'm sorry. That's my fault for asking you. Just last thing, again, and I'm on the other side of this case as we complete this from some of my colleagues, which is a fine. We usually are not unanimous in any event. Is there a distinction between alcoholism, in your view, and crack cocaine, which, based upon your practice, you well know, pervades every dependency court? Could this person, is this result the same if he had a crack cocaine addiction, which he managed to overcome 5 years later?
To be honest with you, Your Honor, and I mean, I'm fortunate that I've never suffered with any addiction issues, but a lot of people and a lot of my clients have. I think addiction is addiction. I think there are different scenarios, and one could say, you know, maybe alcohol obviously might be more accessible in certain avenues than, say, crack cocaine. I guess if you're not going to the right places for something like that, and maybe some people don't know where to buy crack cocaine. But I think addiction is addiction, and I do think that, you know, there could be a stigma in certain places, but there also, when someone is going through the recovery and treatment with, hey, I need to get through this, I have kids, there also needs to be affirmative steps forward, and I think that actually helps these people with their recovery. I've seen so many of my clients that their only motivation for getting and staying clean, or even doing services, period, because some of them aren't motivated to do anything at the very beginning, is, hey, the thought that my kids could be gone.
On that point, wasn't it the father's testimony in this case that the only thing that got him into recovery was the thought of being reunited with his children?
I believe
along the lines of what you just indicated.
Yes, I believe father's testimony was that at least one of his rehabs was his children. He also testified that he did not contact them during that entire time as well. So, thank you.
Thank you very much. That will complete oral argument for Pittsburgh. Appreciate everyone's attention and assistance in these important cases.
Thank you.